Доброго дня.
Good afternoon. First of all, I would like to welcome our international experts who participate in our event today. I would like also to say hello to everyone who are watching the broadcast, and I would like to announce that today we are continue our interviews with respect to establishing compliance with the integrity of criterion. I would like to remind that our candidate received in a timely manner questionnaire with questions with respect to which the Commission tried and hoped to receive explanations. Candidate have provided information which they believed was important. The working group has processed their responses and has provided in a timely manner information to Commission members. Translation have also been ensured in a timely manner, which is why our international experts and colleagues have also been able to familiarize themselves with the answers and documents received from the candidates. Therefore, right now, we will follow up the questions that we had. At the same time, members of our commission may ask any additional questions, including the ones which were mentioned in the questionnaire, as well as the questions that go beyond the questionnaire. I would like to remind that according to our rules of procedure, we have 1 hour for such an interview. If this time slot is not enough and we have some additional question, then the Commission has an opportunity to vote for extension of the interview with a specific candidate. I have a request to our candidates. Please be concise as much as possible while giving answers, because your written explanations have been received by us. We have looked through them. And if possible, please spend up to 2 minutes to answer each of the questions. And then we will see whether we have any additional follow-up questions or not. If we have no other objections or comments, I would like to find out, first of all, with Maxim, whether you have recusal request with respect to any members of the Commission. Thank you. Yeah, by the way, I have no recusal request. Yes, thank you. Then let's move on to our communication with respect to the questionnaire that you have received. Please, according to your asset declaration for 2022, on the 2nd of April of 2020, you acquired the right of ownership for 2015 vehicle Dodge valued at 124,837 hryvnias. Can you please tell us what was the technical condition of the vehicle as of the moment of its purchase, which total expenses you had with respect to the purchase, transportation, customs duties, repairs of the vehicle, and please state the source of origin of respective funds. I understand your question. Thank you. In 2020, our family decided to buy a vehicle which had to have 7 places, because we have 4 children, so we needed to have a 7-seat vehicle. We were considering it for a long time. I love American vehicles personally, therefore I decided to buy a Dodge Journey. We were choosing a vehicle for a long time. We were checking different websites with respect to configuration of this vehicle, Dodge Journey, and finally we decided to buy a vehicle with slight technical damages inflicted as a result of a minor traffic accident. This vehicle was bought in 2020, as I've mentioned. for $4,498. According to the payment order, as of the 2nd of April of 2020, was transferred by me to the account of the American company, which bought the vehicle for this particular amount. Once it was transported to the customs terminal, by the way, damages, I have photos here. If you can see, I've provided photos to the commission. Yes, he sent the photos of this vehicle. Once it arrived to the customs terminal, it was cleared at the customs. I found in advance of our interview a copy of the payment order. Odessa Customs received it from me. 46,460 hryvnias transferred on the 25th of May of 2020. Once I analyzed these damages, it was established that it is necessary to substitute the front bumper lights and to repair the hood. It was done. At first, it was necessary to, of course, to transport it to Kharkiv, where it was actually repaired. It cost me 9,000 hryvnias. And then the total expenses on the repairs amounted to about 73,000 hryvnias, approximately. With all payments and repairs, this vehicle cost me in total about 290,000 hryvnias. The source of origin of these funds used for this vehicle included my salary. Thank you. Our next question is the following. According to available information, your wife rents a land plot with the area 10.207 hectares and a land plot with the area of 17.073 hectares, so with respective cadastral numbers that you know. I will not mention these cadastral numbers, but the question is the following. Please explain why we have this discrepancy regarding cadastral numbers with the area of 10.207 hectares. I understand your question. Thank you. This, I should make a short history in advance. In 2020, there were registered 2 rent agreements by my wife with a private interview with Sakhashinska District Administration of Kharkiv region. She received 2 land plots into rent with 10 and 17 hectares respectively. The cadastral numbers of these land plots are specified in the rent agreements for these land plots. In 2020, due to the administrative reform, these land plots owned by the state were transferred into the ownership of newly established territorial communities. And accordingly, when the land plot was transferred, in particular this land plot with a 10-hectare area, by mistake, the cadastral number was moved to the archive, as I was explained in the state geocadaster. I have also provided the response from the state geocadaster to the Commission for your consideration. And this land plot received a new cadastral number. For example, I didn't know about this situation, which is why I continued declaring the previous cadastral number for this land plot, which was specified in the rent agreement, which is still valid, by the way. And accordingly, now I know, now it's clear for me, and I will declare, of course, a new cadastral number of this land plot. But according to the request response from the state geocadaster, there was received an explanation regarding the fact that the previous cadastral number and the new cadastral number of the land plot belong to the same land plot with the area of 10 hectares. So that is my response to this question about the discrepancy. Okay, thank you. Thank you. When we, since we've approached the land issues, let's call them like that. But so, according to the asset declaration for 2022, on the 29th of June of 2016, you acquired into ownership a land plot with an area of 2 hectares in the village of Hrishivka of Kharkiv region. Can you please specify legal grounds for acquisition of the right of ownership for this property and or explain how this land plot is being used, given that you did not declare any income from the land rent? And please answer the question. Thank you for your question. I understand your question. In 2020, I submitted an application to Darnadezhinsk Village Council, that is where the land plot is located. It is not far from Sakhnovshchina in Kharkiv region, where I used to live with my family. And according to Article 118 of the Land Code of Ukraine, I decided to use my legal right and to privatize 2 hectares for personal agricultural activities. Subsequently, once, for example, when I stopped working, when I retire, for example, this land plot, I have an intention to use it personally. Before that, in 2015, the 3 years there was ongoing preparation of technical documents, development of these documents, and at the end of 2015, this document, the session was adopted. The decision on adoption and transfer of this land plot was, and privatization of this land plot was issued to me in 2016, and then it was registered in the state register for real estate property. And this land plot is used actually by my wife, who cultivates agricultural goods on this land plot that is located not far from there, which she rents, plus on this land plot that is in my ownership following the procedure of privatization. To conclude an official rent agreement with my wife, I see no sense, no meaning to do that, because since I acquired this land plot during marriage, according to the family code, it is our shared joint ownership. So accordingly, my wife can also use it, and she does that. She receives income from this land plot, and she declares them in the general structure of her income as a private entrepreneur on an annual basis. Thank you. Thank you. If possible, then I have 2 follow-up questions regarding this particular situation. My first follow-up question is, can you please explain why this land plot was not declared in your asset declaration for 2016 and 2017? That is my first question. And my second question is the following. As far as we understand, as of the moment of receipt of the right of ownership for this land plot, you used to work in the prosecutor's office of the same district. Is that accurate or not? Thank you for your question. No, that is not accurate information. I stopped working in the prosecutor's office of Sakhnovshchinsky district in 2008. Then I worked at different positions in the prosecutor's office of Kharkiv, in one of the Kharkiv prosecutor's offices, then in the regional prosecutor's office. And once I received this land plot into ownership, I worked in a completely different district. It was Lizivsky district. It has no relation to structurally or administratively to Sakhnovshchinsky district. These are completely different districts. Secondly, why I did not declare it in the declarations for 2016 and 2017 upon dismissal? This happened, as far as I remember, this was in February of 2017. Back then, I was resigning from the prosecutor's office, and it was necessary to submit a declaration about my financial situation, an annual for the previous year, and the declaration before dismissal. It was also mandatory to submit the declaration on the last day of my work. As far as I remember, this declaration was filled in by me several times. I tried to fill in it several times. The software was malfunctioning. Unfortunately, back then, with the leadership of an ACP, the software was lagging a bit, was malfunctioning a bit. So I remember that I tried to fill in the declaration several times. I assume that maybe because of my inattentiveness, I did not declare this land plot. However, subsequently, it was declared in all asset declarations after that. And secondly, there was no meaning not to declare it if we studied the situation because it was received in a legal way. Thank you. In your application of the candidate for the position of the director of the NABU, you provide Sorsky as a person who can provide references to you. And Sorsky Oleg Igorovich is the deputy head of the State Bureau of Investigations in Poltava. Can you please explain the nature of your relations and why you decided to specify this particular person in your application? I understand your question. Thank you. With respect to Sorsky Oleg Igorovich, I can explain the following. This is a former employee of the National Anti-Corruption Bureau of Ukraine. He used to work in our unit, where I used to work as well. Together, we spent time investigating many criminal proceedings. So he knows me quite well. I know him quite well. And because of that, I believe that this person, since he knows me quite well, he can provide respective references to me and describe me both from the perspective of my professionalism and from the perspective of morality. Therefore, because of these reasons, I decided to specify him. The nature of our relations once he resigned from the National Anti-Corruption Bureau of Ukraine, we have kept in touch, but in a quite limited way, let's call it like that. The corporate ethics and of him as the employee of the State Bureau of Investigations and of me as the NABU employee does not allow us to discuss professional topics. However, we continue, for example, congratulating each other on birthdays, New Year, holidays. That is the nature of our relations now. Thank you. Okay, thank you. And one more question to you. According to available information with respect to objects specified in Section 3 real estate objects of your asset declaration, there are the following discrepancies. With respect to the apartment with a total area of 65 square meters, the right of joint shared ownership for which was acquired by your wife, your mother-in-law, and a third person, in 1996 valued at 1,388 hryvnias as of the date of the right acquisition, according to the most recent monetary estimate. According to information, there is no information from the State Register of Property Rates. Similarly, that is about the garage with an area of 18.8 square meters, with the right of ownership for which was acquired by your mother-in-law on the 5th of November of 1996. Can you please explain the situation? Thank you. Your question, I understand your question. With respect to this, I can explain the following. Since 2007, from 2007 to the end of 2022, I used to live together with my brother-in-law in this apartment and with my family, of course. According to her, to my mother-in-law, this apartment was transferred to them during the Soviet times. The building was built in 1985. That is a multi-apartment building. There is even a plaque with in bricks with the date of its construction, and starting from since before the collapse of the Soviet Union, they received this apartment. According to my mother-in-law, the owners of this apartment were her late husband, her daughter, and her son. The only document that we could find, that my mother-in-law could find, right? When she started looking for documents, and when I was filling in the declaration, I needed some document which could confirm any rights why she lived in this apartment. So we found the certificate on the right on inheritance from her late husband, according to which the share of her husband was inherited by the mother-in-law, her daughter, that is my wife, and her son. However, the information into the state Univate register of property rights were not entered by her. She has not done that till now, because for that it is necessary to go to the archive to look for the decision when this apartment was transferred to her into ownership, etc. So that is my answer. Similarly, with respect to the garage, that was similarly inherited by her after the death of her husband, in 1996. And this document, the certificate on the right of ownership according to the will, as a result of inheritance, have been provided to the Commission by me. Thank you.
Thank you. So, currently, we've had a few questions, but you've been able to provide the answers that were satisfactory to the members of the Commission. I will not go into them any further. I have no further questions. Do any members have questions? I'll go over to you.
Yeah, thank you. Good morning. So my question is about the following. In that was 2017, there was a case, you're familiar with it, when the court acquitted, let's say, 2 persons from Vinica. And you were the prosecutor. If I got it right, you were the prosecutor in this case. And after you gave the explanation that you said that the investigation team did not collect enough evidence and they made some procedural violations. So if you're the prosecutor in the case, why didn't you realize those mistakes and faults of the investigative team before? Why did you wait until the end of the process, until the end of the trial, and then explain what happened?
Дякую. Питання зрозуміле.
Thank you for your question. Your question is clear. This must be a mistake. To be honest, I do not remember a case in 2017. In early 2017, I worked for the prosecution office of Lozivsky district of Kharkiv region. Could you please give me more details about the case, because I cannot remember a case of that nature. Since January 2017 was the day when I retired from the prosecution office. First, I took leave and then I retired from the prosecution office. I cannot recall a case.
The number of the accused person was Sergei Shevchuk, and another one was no, he was a businessman and local councillor Mikhail Podilsky. So does this name ring a bell?
Ні, на жаль, мені не знайомі ці прізвища.
No, unfortunately, I do not recognize the names. There must be a mistake. I do not recall this case. Could I see the court decision or the court verdict? Please, can you tell me the particular court that issued the verdict, the name of the court, please?
Well, we just have the information on the court. It doesn't say which court. I will try to find it and I'll get back to you. Nikolai, I suggest we continue and I will try to find the name of the court.
Дякую. Буду чекати.
Thank you. I'll wait for your answer. I'll wait for the explanation. Alexei, over to you. So, please tell us, you've been a prosecutor for 12 years. Maxim, in 12 years of your service, have you come across the manifestations of corruption on the part of your colleagues in the units that you had engaged with professionally? And if yes, how did you respond or what did you do?
Дякую за запитання. Конкретно
Thank you for the question.
конкретних корупційних
As for the specific information about the particular corruption offenses on my colleagues was not something I could report. There were rumors.
ставив під сумніви.
Some people had doubts about the decisions made by
Так, це було.
some colleagues in the prosecutorial service, but nothing specific about the corruption crimes that I could report to you. Thank you.
Будь ласка, ще питання.
Do we have any further questions? Кирило, over to you. Maxim,
В своїй автобіографії зазначили,
in
що
your biography,
разом із сім'єю
you have stated that you are living with your family in Sakhoshchina
проживати
and
в тому ж населеному
you are planning to stay on living there. So do I understand you correctly that you're working in Kharkiv and you commute to your job and you commute back and you don't have a permanent place of residence in Kharkiv or a place that you're using, an apartment or some other place?
Так, дякую. Питання зрозуміло.
Thank you for your question. It is clear. I drive to join my family for the weekend. In Kharkiv, I'm renting a place. It's stated in the declaration. It's an apartment. It's located in Kyiv district of Kharkiv city. The rent fee per month was 5,000 to 7,000 hryvnia, including utility fees.
З комунальних платежів виходило, стільки платили.
Well, I paid whatever utility fees were due,
Задекларовано.
and I have declared this in my declaration. Thank you.
ще є питання. Скажіть, будь ласка,
I have another question.
чи з таким
Tell us, please.
пов'язує з такими особами
Have you ever dealt with, is anything connecting you to the individual's Gagan? It's a local councillor from the opposition bloc, and he's also the leader of the local district of the opposition bloc and leader of the Kharkiv organization Opora Slobozhayshchiny.
якщо у вас
Are
пов'язано?
you acquainted? Have you ever met? And is anything connecting you? Thank you for the question. Nothing connects me to the individual. I know him. I used to work in Lozova
Заступником керівника місцевої
as deputy head of the local prosecution office, the first deputy.
мав право на заняття адвокатською діяльністю.
He had
Адвокатом і, власне, напевно, і
license as an attorney. He must be an attorney still. So
представляв інтерес.
he acted as a defense counsel in a number of criminal proceedings. So I know him personally, and there's nothing connecting us. Thank you. Thank you.
Дякую. Якщо
Thank you.
питань немає, можете бути вільними.
If there are no further questions, we can let you go. Thank you. All the very best.
Продовжуємо наш захід.
So let us carry on
Співбесіда з
the interview with Gupyak Serhiy Leonidovich. I would like to remind the esteemed candidate that we have sent you the questionnaire containing the questions that the Commission would like to inquire about, and we would like to receive the explanations and the documents. So our interview will mostly deal with the questions contained in the questionnaire. To streamline our communication, drawing on the experience of yesterday and today, we have grouped the questions into blocks: the income, vehicles, real estate, and others. This does not rule out that we may have additional questions that are not linked to the questions in the questionnaire. We would like to ask you, since our time limit is limited to an hour, if you would please take 2 minutes to give us an answer. No need to go into detail and give us reference into the cadastre numbers, dates, and further details, as the members of the Commission have it before themselves. Both we have it at the tables, and our international experts also have the documents translated before them. So before we begin, I would like to ask you whether you would like to recuse any members of the selection committee. No, I would not like to file a recusal. Thank you. Then let us transition to the questions. So, in 2007, you have, together with your father, Leonid Gupyak, you acquired a land lot with the area of 2,000 square meters, a non-residential building in Lukashivka of Vinnytsia district. The declared value of the property comprises 240,000 hryvnias. On the 2nd of November 2018, you have declared the receipt of income from the sale of the share in the property for 393,000 hryvnia. So, if you could please elaborate the source of income for yourselves and for your parents. Thank you for this question. I would like to say outright that in 2007, I was a 4-year student of the National Law University, then named after Yaroslav Mudry, and I did not have the source of income to buy the assets. Still, as you have noted correctly, the purchase of the asset was done by my parents, who had the income and the opportunity to buy the said land lot and property in 2007. When answering the question, I have provided the supporting documents as to the possibility of my parents to buy the assets. I provided a copy of the mortgage agreement, according to which my mother had taken out the money amounting to $40,000. Later on, the decision to document the title in my name and in the name of my father was made by our family for the following considerations: that perhaps in the future, if my father changed his line of business, or if I did not pursue my legal career or my law enforcement career, this could be a place for us to do business together. Therefore, the decision was made to make use of the money belonging to my parents to document the title on the said land lot and property. And also, I would like to state further, as I did explain in my answers that my mother is a private entrepreneur since 1999, and she has been private entrepreneur till 1919. She had her savings from her business. To say whether they were enough, we can judge that based that after the acquisition of the said assets in 2007, 3 months later, she had settled the loan amounted to $28,000. So she settled the majority of the loan. And this indicates that they had taken out the mortgage, but also had legal sources of income. And I was a student at the time. Thank you. We have a number of questions to do with your ownership of cars. So, according to the information available to us, on the 6th of November 2018, your father bought Opel Zafira car made in 2013. Would you tell us what are the legal grounds for the acquisition of this vehicle, its value, and whether this vehicle was bought by your father with his own income? Thank you. Thank you for your question. Indeed, on the 6th of November 2018, the right of ownership was registered to my father. According to the explanations of my parents and the documents they have supplied, they've spent $11,200 to buy the car. The acquisition of this car came after a number of legal deeds, after they alienated their right to another vehicles owned by my father. I cannot disclose the nature of these legal deeds as they include third parties who are not declaration subject, and I'm not free to disclose the details, since I fully confirm that my parents were capable and had the means to buy the vehicle worth $11,200. This is confirmed by following documents submitted to the Commission. In particular, in 2010, alienation of a real estate object was made belonging to my mother. Since 2003, 363,400 revenues were received for the alienation of this property. According to the going exchange rate, the parents converted the amount, and this amounted to $46,000. That's my first point. Secondly, on the 2nd of November 2018, my parents alienate another property, a landlord. According to this, they have received 161,000 hryvnia. At the going rate, it's $5,000 plus. Also, my father owned a vehicle, Opel Zafira of 2003 make. According to his agreement with the intermediaries and third parties, the deal, there were several legal deeds made, and that including concession of his right to this vehicle and the payment of the remainder amount. In this connection, I feel I have fully confirmed the ability of my parents to buy the vehicle as of November 2017 at the stated price and even at a times higher price. If we just do the math and put the numbers I have provided together. According to your declaration for 2021, on the 8th of October 2008, you acquired ownership on a vehicle, Fiat Ibiza of 2005, owned by your father. What are the grounds for the acquisition of the said asset by your father, its value,
придбав
and whether your father bought this vehicle with his own income.
Дякую за запитання.
Thank you for the question.
Стосовно зазначеного транспортного засобу,
As for this car,
здійснення правочинів щодо
the legal deeds pertaining to its acquisitions happened in April 2008. I'd like to underscore that at the time I was a fifth-year student of the law university. At the time, indeed, this was a paid legal deed based on the funds available to my parents. The car was worth $12,000, and I can confirm the ability of my parents to acquire the vehicle, and that is the loan taken out by my parents and the business run by my mother since 1999. At the same time, steps were taken to ascertain the details about this vehicle, but my father applied to the service center, and it was established that there are no documents on the documents dating back to 2008 because they were no longer preserved. And since my parents lost the documents on the vehicle in 2008-2009, therefore I could not report the value as I'm using the vehicle. My wife uses the vehicle. So, this is something I would like to explain why I haven't reported the value of the vehicle in my declaration. Still, I believe that I have provided ample documents proving that my parents were in a position to buy the vehicle. It was registered in October 2008, and according to the registration certificate of the car, I am listed as a person eligible to drive it. Fine, thank you. And I have one last question so far about vehicle. According to the property declaration for 2021, yourselves and your mother acquired equal shares in shared ownership of a vehicle, Toyota RAV4 Hybrid of 2021 make, worth 929,787 revenue. Would you please explain what sources of income were used to buy the vehicle on your part and on the part of your mother? Thank you. Thank you for the question. Indeed, in 2021, my mother and myself bought out this vehicle on equal shares, in equal shares. I provided 464,000. I can offer the documents. I have provided the relevant documents to the Commission about me being able to afford this part of the value of the vehicle. I sold a real estate in a land lot that you had mentioned that I partially owned back in 2007, since 2007, but in November 2017, I alienated it, and consequently, I received the funds amounting to 292,000 revenue. The said money were declared by me in 2018 and saved until the purchase of this car. Also, I had my own savings, 94,000 revenue, that I had saved up over the years of working for the prosecution service, that I had also declared in 2018 because the funding were over the threshold, so I declared the money. Also, when I was leaving the prosecution service, I was paid a compensation for the vacation I had not used, and for the last month of my service, I received a bit over 250,000 hryvnia, excluding taxes. And after the payment of taxes, that comprised 205,000 hryvnia. So the mathematical calculation shows that I had money well in excess of the down payment for the car. As for my mother and her part, I have also provided the documents to the Commission, and that is the purchase sale agreement of 2010, when my mother had received $46,000 that they had saved. Some money, some part of it was to settle the loan and for her business, but she saved most of it until May 21, and she transferred $70,000. She converted them to hryvnia and provided the missing part that was needed to buy the car. Therefore, I feel that I have fully confirmed the ability to afford this vehicle on my part and on my mother's part, to say nothing of the business owned by my mother and the income she had generated, because that would mean that I could disclose the information that could endanger her. And I would not like to talk of her savings as of now. Fine. Let us transition to the block of questions that are more ethical in nature.
Скажіть, будь ласка, в соціальній мережі
Can you please tell us, in Facebook, civil society organizations appear and its head Valery Denisov in April of 2008 published the materials with respect to you. Can you please provide the explanation or your own vision with respect to the information that is given in these Facebook publications regarding circumstances of the death of Don? Thank you for your question. My response to this question, I will build out of two components. The first component concerns the death and circumstances of the death and investigation by me of the death of the person that you've mentioned, and the other part of the answer would concern the reasons of publications from this person in Facebook, as well as the reasons concerning the position of the victims, which was copied by the representative by the head of the civil society organization in his publication. With respect to the death of the investigator, I can state that in 2010, I worked as the senior investigator of Staromysky district prosecutor's office in Vinnytsia. I worked there for less than a week since my appointment. And in the second half of the day, in the afternoon, we received a call, a signal from the district police department that in one of the offices, an investigator died because of the gunshot wound. Accordingly, prosecutor of the district, prosecutor of the city, the then head of the regional prosecutor's office, investigators from different units, including me, came to the scene of the event. The crime scene was investigated by another investigator. I'm sorry. We are talking about specific criminal proceeding. What was the end of the criminal proceeding, so that we would not now disclose the secret of the criminal's investigation. I understand. This information that I'm going to publish will not be a secret of the pre-trial investigation. With respect of the death of this investigator, the procedure is ongoing. At the same time, there is a verdict of the Supreme Court with which, with respect to some circumstances that happened on the 19th of May of 2010, a person with a qualification of negligence and improper use of fire weapons was convicted. And this decision gives circumstances with respect to this. But at the same time, I would like to point out, without disclosing the secret of the pretrial investigation, that I became the main investigator under this proceeding once it was initiated. So the prosecutor determined the qualification under Article 367. At the same time, this is also available in the prosecutor oversight materials, but I doubt that the materials of the criminal proceeding include that. But on the first day, I developed the plan of the pre-trial investigation, according to which we had 4 versions of events. And the version with respect of professional negligence was not the main one. We had 4 different versions, that is homicide, accidental murder, and bringing to suicide, and negligence. And neither of these versions was the main and priority. They were all equal. I was appointed as the head of the group, and we developed a plan of investigative actions aimed at identifying and studying each of these versions. Then, in my explanations, I provided the explanation of investigative actions. Then the group was changed. I had this proceeding for less than a month. Over this period of time, I did not receive any unlawful directions or orders. I didn't receive any decrees during that period of time. And after that, for over more than 12 years since that event, I have never received any official comments regarding improper investigation by me from persons who have the right to initiate this issue. So I have never been criticized or regarding my incompetence or improper investigation. So all this is clear. And let's move on to the second part of your answer, if possible, with respect to your vision, why this society organization was so interested in that. At the same time, the victims under this proceeding, and they have all rights for that, remain at the position that the death of their son happened because of homicide. They have repeatedly mentioned their position in social media and expressed to other people, and they believed that other versions were versions and evidence regarding other versions were falsified. And they accused all the professional persons or officials who were somehow related to this investigation of that, investigators, prosecutors, etc. So therefore, there emerged such a negative attitude towards this proceeding. This negative opinion was copied by a representative of the civil society organization, namely Sophia, and posted in the publication. Why did he do that? I have 2 versions why he used that in his publication. The first version is that a subordinate plea to me in 2016 submitted an appeal regarding this particular head of the civil society organization. Pursuant to the result of this appellate proceeding, he received a verdict in which he was accused of committing corruption actions. This verdict was enforced and it was entered into the register of corruption. The other circumstances why this person might have negative attitude towards me and my activity is our justified position with respect to a range of his complaints and range of criminal proceedings registered pursuant to his applications. So I believe that these publications are sort of a way of influence. They are unjustified, they have no confirmation, no circumstances to confirm them. Okay. According to the opinion on results of the official investigation as of the 10th of December of 2021, there was established that your actions as the head of the unit and the prosecutor of the same unit, Onufrienko, as the senior prosecutor of the group, had miscalculations, because of which improper fulfillment of professional duties by BBLAC has become possible. Can you please explain this? Thank you for your question. It is necessary to at once point out that as of this opinion publication, I was working in the State of Bureau of Investigations and not in the prosecutor's office. So I did not familiarize myself about this opinion. I didn't know about it. Having received your questionnaire, I sent request to Vinnytsia Regional Prosecutor's Office, where I was provided with this opinion, and you have a similar question in this questionnaire. And then I clarified that you mean Kutak? Yes. Let's combine these two questions at once, because I just want to announce that according to the opinion on the results of official investigation as of 2021, it was established that your actions as the head of the unit contained miscalculations, which resulted in the fact that it became possible for the prosecutor Kutak to fulfill his professional duties in an improper way. Yes, they are similar, identical, and they were prepared almost at the same time, November, December 2021. I would like to mention again that I was not working in the prosecutor's office, and I have recently reviewed these opinions. In addition to having some miscalculations, there are no other justifications in these opinions regarding my activities. There are no references to the provisions on the management when allegedly my subordinates committed failures in their activities. The essence of both situations consisted in the following: that prosecutors, after getting the other party got acquainted with materials of the case, the prosecutors did not send the indictment bill to the court in a timely manner, which is why there happened a delay, the failure to comply with the terms. According to Article 284 of the CPC of Ukraine. This violation, we can debate for a long time about this, but I would like to say the following: that back then we knew about this position of the court, about the application of this article that they used these days once the other party got acquainted with the materials, and they included them into the term of the pretrial investigation. And the prosecutor provided the respective explanations, but at the same time we also had decisions with which we changed the position that it is impossible to apply this provision. But the prosecutors, as stated subsequently by the courts, in both cases they missed one or several days, as a result of which the court believed that the term was missed. These prosecutors were not brought to disciplinary responsibility. At the same time, I would like to point out that as authorities of the head of the unit, as I was the head of the unit, did not include supervision over the indictment bill from the prosecutor to the court. Explanations regarding to the prosecutor's work and the court was carried out by me. Prosecutors knew about this position. Yes, please, Kirilo. Sergey. Missing the term regarding the indictment bill results the closure of the proceeding, and it results in the undermining of the result of work of the prosecutors. And I know that you got acquainted with these opinions once you started working in the State Bureau of Investigations. Can you please tell us? You say that there is no guilt of yours in this, but what do you believe? A prosecutor which oversees other prosecutors doesn't have to control these issues, or maybe there is some other reason of this answer? Thank you for your question. No, I don't believe that as a head of the unit, I didn't have to control my subordinate prosecutors. At the same time, to control sending of the indictment bill from of every indictment bill to the court. And back then we sent over 100 indictment bills to the court per year. It is physically impossible for the head of the unit to do that. And I would like to remind you that according to the Criminal Procedure Code of Ukraine, the prosecutor procedural management is obliged to send the indictment bill at once to court. Of course, it's clear that those measures from me include explanation regarding the case law, discussion of this case law, possible consequences, and I did all of that. But there is no direct obligation, direct duty to oversee all the letters to the court. So you received information that you were brought to responsibility once you received our questionnaire, right? Do you have any plan to challenge this decision or to leave the situation as it is? Do you have any future plans regarding your activities, regarding these opinions and these decisions? Thank you for your question. I would like to point out at once, no, neither I nor prosecutors mentioned in these opinions have not been brought to disciplinary responsibility. With respect to me, this opinions contains the phrase that is given not in the resolution part, but in the description part. It consists of one sentence. At the same time, it is necessary to take into account that head of the unit Hupak had miscalculations in words, which facilitated untimely sending of indictment bills to the court. So yes, really, I expressed my indignation regarding the fact that I was mentioned in these opinions of the official investigation. But at the same time, there are no legal consequences with respect to me. Therefore, I see no point to challenge them. Can you please tell us, as of now, you are the head of the respective unit in the State Bureau of Investigations, the territorial division located in Vinnytsia. That is a very important question from the perspective of procedural oversight. As far as the Commission knows, your close relative, your wife, as far as I understand, works in the prosecutor's office. So the prosecutor's office where your wife works oversees activities of your unit of the State Bureau of Investigations, or do you see any conflict of interest in that? Thank you for your question. At once, I would like to point out that this question has been raised by me personally and by representatives of the civil society as well. My wife works in the representation unit of the Vinnytsia prosecutor's office that has no procedural duties regarding the unit of the State Bureau of Investigations based in Vinnytsia. We never come across each other regarding procedural or other professional duties with respect to these issues. This issue has already been studied by the internal investigation unit of the State Bureau of Investigations, and there are no criticism points regarding this. Okay, thank you. Drago has a question as far as I see. I made a pause because Kirilo was having questions, so Drago, now you're welcome to ask your questions.
Yeah, well, if you're watching the first candidate, then you know what I will ask you. So, in 2017, in the so-called chief case, the defendants were acquitted, and then you, as a prosecutor, called a press conference and gave the explanation. You said that, let's say, the investigation team did not collect sufficient evidence, and that they made a number of procedural violations. So, don't you think that you, as a prosecutor, would have to, let's say, to deal with all these problems before going to the court, and not afterwards commenting the acquittal of the defendants?
Дякую за запитання.
Thank you for your question. But at once I would like to point out that maybe you have been provided an incorrect interpretation of the situation that happened. Actually, in this situation, I and my subordinate prosecutor, who was supporting the accusation regarding this defendant that you've mentioned, had a completely different position. We had a position that this acquittal verdict that was adopted in 2017 was adopted with violation. In particular, the court did not properly investigate evidence provided by us. The court denied without justification to satisfy rate of motions by the accusation party. And during several days, the court has managed to study all the evidence on the proceeding and to adopt, having denied all the prosecutor's motions, having denied in accepting all evidence and proof, and even the motion about leaving the interim measure, and quickly adopted a verdict with which acquitted this person. We did not agree with this position of the court, and this was a very scandalous situation in the society. And my press conference consisted in the following, that we could explain to the journalists and the civil society that the prosecutor's office stands behind the evidence that it provided and believes that it was possible to prove the guilt of this person. Besides, we showed obvious biased position of the court during the consideration of this proceeding. My message during the press conference back then consisted in the fact that we tried to show to the civil society that the prosecutor's office was ready and would not leave these violations of the court without appeal. And we really submitted an appellate application, and then and we won during this appellate procedure. Actually, my subordinate prosecutor won. And this acquittal verdict was quashed, and this person is still among defendants, and the court proceeding is ongoing. So my position during the press conference was not that I was explaining to the public that we committed some violations or that we had some shortcomings in work. I was explaining that we were defending our position, previous position, that we knew how to submit an appellate application, we knew what we had to emphasize, and that we were convinced that our appellate application would be satisfied, and it was satisfied. Thank you. Yes, please, Kirilo has a question. Sergey, while answering the question of Drago, you stated that this person is still among defendants. As far as I understand, this means that the appellate court quashed the acquittal verdict and sent the case for new consideration to the court of the first instance. So right now, currently, the consideration is ongoing. Don't you think that not a violation, but as an interference with ethics on a fine line, your expressions with respect to incorrect actions of the court, that you are saying that you believed that the evidence was collected in a proper way? Okay, that you believe that the result would be as you say? Okay, that's also great. But do you think that a prosecutor or a head of the pretrial investigation body has the right to criticize the court on the decision before the final decision is adopted? Thank you. Yes, thank you for your question. If you have an opportunity, I would like to review my publication, my press conference in 2017. Back then, I took into account circumstances with respect to possible interpretation of my expressions as the influence on the court. But if you watch my press conference attentively, it is built in such a way that I did not mention criticism or accusations or assumptions with respect to the court. I clearly stated that there is a case law with which some position of the court is recognized as incorrect, unjustified, as a significant violation of the process and the substantive law. I mentioned why we believed that way, because we thought that we submitted proper evidence in a timely manner, and I just told the public about the proceeding, about the process, about the intensity of the actions, and the response of the court to our motions. So the court officially denied in satisfying all our motions, in upholding the interim measure without knowing the decision that it would adopt. And my press conference was as tolerant as possible, using clearly facts which were publicly known and based on decisions that were published.
I have a follow-up question, if I may. Throughout your work for the State Bureau investigation, have you been disciplined? That's my first question. And secondly, have any matters about your being held disciplinary accountable been initiated? Thank you for your question. I'd like to state that while working for the State Bureau of Investigations, I have not been held to disciplinary liability, and this matter has never been initiated. Thank you. Do we have any further questions for this candidate? Alexei, you're welcome. Thank you.
Стосовно тих питань, що задавали колеги,
As for the questions raised by my
з причини
fellow members,
питань до ефективності ваших підлеглих.
questioning the performance of your subordinates, how would you feel about a situation when your subordinates are not performing their duties effectively, which can lead to ineffectiveness of the organization you're leading or unit you're leading, and that could
Як ви на неї реагуєте, як ви відноситесь?
negate the efforts of many people? How do you feel about it, and what has been your custom? Thank you for your question. If my subordinates make a violation, then their conduct needs to be assessed comprehensively. We should not simply look at it at face value. We can refer to the situation discussed. As far as I know, there were several. So, let's say my subordinate doesn't file the indictment within the deadline. If you look at the face of it, we could say that he made a miscalculation of the terms. But if you look at the two specific scenarios, I remember them, and I remember the people behind them. I know the way the indictments were delivered, the workload on the prosecutor, whether he had the opportunity to deliver the indictment in time. We always need to look at the situation comprehensively to see the nature of the violation, whether the prosecutors try to prevent it, and we need to make objective findings. Here, the prosecutors were not disciplined, so sooner than not, as for the objective reasons, direct causes were not established, nor was intent proven. If that was proven, I would have supported charging them with disciplinary liability. I didn't mean disciplining the subordinates, but I asked the question broader. This is a common occurrence. So, supposing you were elected to the NABU director position, similar events or same events could unfold. So, apart from making an assessment, a comprehensive assessment, what further steps would you take, or would this be all you would do? I would not go into the details of the procedure. If an incident happens, there is a disciplinary board to review it and present the findings to myself. As a director, I will look at the situation from other information sources. I will talk to the heads of the department, try to look into the matter and make the decision objectively. If this was done with intent, then the person would be disciplined. The facts would be made known to others to prevent similar occurrences from happening. If I may ask one more question, when giving us the answers in writing and here during the interview, you have often omit certain information pertaining to the
посилаючись на те, що це
counterparties of your parents, saying that they are not declaration subjects and in some other matters. If you could please give us an extended answers as to why do you feel it is important to disclose the information about the third parties? Thank you for the question. Under the law of Ukraine on the prevention of corruption, the family members of the declarants who are then overseen by the National Agency for the Prevention of Corruption. This includes the circle, the close family circle, the wife, the spouse, the children, people living with the declarants. My parents are not declaration subjects. For the purposes of the Commission, they have provided the information that they felt they needed to. As for the third parties, their names, their personal information, by disclosing them, I may encroach on their rights. I may disclose the information about omissions they could have made. Therefore, I don't have the right to mention the third parties and identify them and speak about their dealings, because apart from others, I'm not a party to the legal deeds that you feel I have not covered sufficiently, nor is my wife. We didn't know the intents of our parents. We didn't know the counteragents that they entered the legal deeds with. So this was my reasoning, because by providing the explanations and giving you my answers, I could unwittingly encroach on the rights of the third parties. Then I have a question. Apart from your close family, should you become the director of the National Anti-Corruption Bureau of Ukraine, would you also feel that you'll have no connection to your relatives apart from your closest family? Despite ongoing relations and despite the duties and responsibilities with these close relatives going beyond your immediate family circle as the declaration subject. Thank you for your question. I could pose a counter question. Do I have the duty to control the people whose data I'm under no duty to report? So I do not have the duty. I'm not a family lawyer, although of course I have legal background and I am a supervisor in order to offer legal advice to my relatives. If they asked me, should I enter this deed and how do I best do it, if I felt they were doing something wrong, I would have told them so. You see, a lot of violations, including corruption offenses, can be made by the public official and their family circles indirectly. There's the phenomena of nepotism in Ukraine, but let me go into the question explicitly. We would know that if you were to hold a position tomorrow, and should you be questioned about your immediate family, what they do, you could say in response that you are only accountable for your wife, and as for your further circle and your friends, you're not accountable for them, and you are not free to disclose the information according to the law. Do you understand you correctly? Yes. Under the law, I will just make one short remark. If there is reasonable doubt about the NABU director being implicated in some illegal dealings and his friends or relatives are implicated, then the director has to be held accountable under the law.
Мені здається, не збігатися загальна думка, тому що
We may have a difference of opinion because if the Commission asked you to provide the information about the third parties, or if you're asked about it in the future, it's not out of pure interest. It may be because the third parties may have the links to yourselves, your parents, etc., etc.
це не зовсім
And
суб'єкти, які відособлені, відокремлені.
they are not entirely unconnected to the situation. That needs to be clarified. It's not a question, it's a comment. If I may say in response, you're the chairman. I wasn't asking you. Okay, I see.
Сергій Леонідович, у вас в розділі анкети, яка стосується
So,
рекомендацій,
in the
3,
section of the questionnaire,
2 з них
recommendations, you list 3 people:
Генерального прокурора.
Deputy Head of the Department at the General Prosecution Office and the advisor to the General Prosecutor.
Хотів би поцікавитися,
So I wanted to ask you, how did you meet these people and why do you feel these people can give you a reference, positive or negative, whatever it may be? Thank you for the question. The person working as an advisor to the General Prosecutor is also working in an international organization and is also an attorney, is also a person I went to school together with. I know him since childhood. He shares my principles about transparency, integrity, professional conduct. This person knows me from my childhood, through my studies, and through my professional career in the law enforcement. So therefore, I included this person as my referee. As the second person, who is the deputy head of the department at the General Prosecution Office, this is also a person I went to law school together with. We studied together in the law school, and we also share our principles, and he can talk of my integrity since student times and that through my professional career. Thank you. If we don't have any further questions, you may be free. All the best. Thank you. Thank you.
Продовжуємо наші
Let's
співбесіди.
continue our interviews today.
Кандидат
The candidate Kravchenko Ruslan Andreevich is with us in the room. I would like to remind you, you received the questionnaire. We received your answers to questions that caused some misunderstanding among the Commission members. Some of them have satisfied us, and we would like to discuss and hear additional explanations with respect to some of them. At the same time, we have formed several blocks. So we are talking about 3 blocks: questions concerning income, questions concerning property, and questions related to some ethical issues. This way, we will beat our interview. It doesn't mean that all questions will be discussed, but it doesn't exclude as well that some Commission members may have follow-up questions which are not related to the questionnaire, probably like a comment of some aspects. Before we continue our communication, I would like to clarify and find out whether you have any recusal requests with respect to the Commission members who will interview you now. Dear Commission members, I have no recusal requests. Thank you. Thank you. Then let's move on to our interview. And I would also like to ask you, you have provided very detailed answers in writing, but while answering orally, please do not repeat what you have already provided in writing. So please be concise, up to 2 minutes while answering the questions. Of course, we can exceed our time limit, but it will have to be an additional decision of the Commission to continue and extend our interview. So we have what you've sent to us in writing. It has been translated and sent to our international experts and members as well. So we have everything in writing. So please, your concise comments only. Okay, thank you. So the first block concerns questions related to income. In your asset declaration for 2015, you specified that your income during the reporting year amounted to 255,830 hryvnias. As of the end of 2015, you did not declare any savings. At the same time, since July of 2015, you have rented an apartment in Kyiv. In turn, in the declaration for 2016, you declared income in the amount of 231,287 hryvnias. At the same time, you also rented an apartment, the same apartment in Kyiv during the entire year. Can you please explain to us whether you declared in 2016 your own funds in the amount 162,000 hryvnias? Dear Commission members, thank you for the question. I can explain that at the end of 2015, I had savings which, according to Article 46 of the Law of Ukraine on Prevention of Corruption, were not subject to declaring. In particular, my savings did not exceed 60,900 hryvnias. In 2015, I saved 60,000 hryvnias. As of the end of 2016, I had savings in the amount of, only for 2016, in the amount of 102,000 hryvnias. So over the 2 years, I had savings in the amount of 162,000 hryvnias, which I declared. Besides, I have not provided, but I had a request from the Prosecutor General's office to the NCP, and the NCP denied in satisfying this issue because no offenses were revealed. Okay. My next question is, according to available information, on the 12th of July 2017, your mother, based on the sale and purchase agreement, acquired the right of ownership from an apartment with an area of 38.8 square meters, located in Kyiv, valued at 949,145 hryvnias. This real estate object was sold under the sale and purchase of agreements in 2022, and the price amounted to 1,381,185 hryvnias. The buyer of this real estate object was your sister Kravchenko Anastasia. So please explain whether your mother used her own funds to buy this real estate object and state the course of origin of these funds. Thank you for your question. The question is clear. If you allow, I would like to explain the following. Since 2005, I have been living not in the family of my parents because I entered the Kyiv Lyceum. So actually, since 2005 till now, I have not lived together with my parents in the meaning of the anti-corruption legislation. I'm not a family member in the meaning of the anti-corruption legislation. As I just said, we have not had shared household, we did not live together, and we have not had and do not have mutual rights and obligations with my mom, father, and sister. Since 2005, actually, my parents have not funded my household since starting from the military lyceum. I was studying for free and I was living for free. Since 2007, I was studying in Yaroslav Mudry National Law Academy, studied for free, lived in a dorm, and also received scholarship. However, sorry for interrupting you, but in your answers you provided, you do not need to quote your answers in writing. So because otherwise it will take a long time because we will be just talking for 2-3 hours with you. Sorry, I will amend my approach. We have all the documents that you've provided, so just please comment on the situation. Yeah, I have provided an application to the Commission from my father, from my mother, and from my sister, and all of them have been notarized. The purchase of the apartment took place. I would like only to add that this was joint shared ownership of my parents, that is mom and father, and not only my mother. The apartment was bought using their own savings accumulated during the entire lifetime. Firstly, since 1991, to 1997, my father was engaging in entrepreneurial activities. Secondly, they sold the business. They sold movable, immovable property. My mom received salary. My father received salary. My parents received inheritance from their parents. They had income from the rent of property owned by them. I have provided supporting documents to the Commission, which my parents have provided me with. My father has really preserved all the documents, confirming documents that when he was engaging in entrepreneurial activities from 1991 to 1997, he paid, as he told me. Now he receives a pension because of disability. He wanted to increase it because, in his opinion, he paid taxes during that period in the amount of $16,000, and he believed that it was possible. But he lived in Severodonetsk, and because of the war against our country by the Russian Federation, the building where my father preserved all supporting documents was completely destroyed. I provided all the materials to the commissions, to video, photo confirmations, as well as my father's application to the Special Commission. Besides, my father didn't have, but his sister sent additional documents which she had photocopies. The Commission has not received these documents yet, but this was the inheritance to the bank account from my father's mother, that is my grandmother, and my father and his sister inherited this. And I would like to provide these additional supporting documents that I've received from my aunt. Yes, please transfer these documents to the representatives of the working group after the interview. The next question. In your asset declaration in section 6, you specified the right of ownership of your wife for vehicle Mercedes-Benz 250 value as of the date of the right of possession, or according to the last monetary estimation, amounted to 124,081 hryvnias. At the same time, the value about the price of this information is absent from the Unified Register of Vehicles. Please provide explanations. Dear Commission, thank you for your question. I have provided all supporting documents why my wife declared this amount of 124,081 kopecks. The vehicle was bought in the US. The supporting documents that its value amounted to I've explained that my wife submitted in 2017 this declaration, and the ECP's declarations were not valid back then, whether it was necessary to declare customs clearance or not. And in order to submit the declaration about change in the property situation and to explain and to record as much as possible the value and the amount of expenses, she has provided, she added all taxes, all logistical expenses, etc. About the condition of the vehicle, I've also provided documents about the expertise. It was damaged. So therefore, all the documents confirming the value and the amount of expenses of my wife have been provided. And the estimate, according to the expertise of this vehicle, was that this vehicle cost 96,000 hryvnias. But the customs estimated this vehicle at 114,000 hryvnias. So she received this amount. It was declared while adding up all the expenses. So she provided all this information. I have all the supporting documents confirming my words and all the explanations, and I have sent all of this to you. Okay, thank you. Our next question is the following. In your asset declaration for 2019, you specified that your wife, on the 16th of January of 2014, acquired into ownership an apartment in the central part of Kyiv with a total area of 89.9 square meters, valued at 503,000 hryvnias. Taking into account the fact that this apartment of your wife was acquired by your wife under the deed of gift, can you please explain what were the relations between the person who gave this gift and why this property was gifted to your wife? Thank you, dear Commission, for your question. The question is clear to me. I would like to explain that our marriage started since the 15th of March of 2019. The property was acquired by her in 2014, that is 5 years before our marriage. I've provided my wife's explanations to the Commission. I asked her to provide the answer to this question because this property is private ownership of my wife exclusively. I do not have any rights for this property and will never have rights for this property. I asked my wife to provide explanations. My wife has not provided the application statement not authorized by the notary. She has said that I have no rights about this for this apartment, and that she didn't want to provide any information about the nature of relations with the person who gifted this apartment. And I have provided my wife's statement to you about that. Okay. Can you please tell me, with a decision of the Bar Council of Poltava region as of the 21st of July of 2007, you acquired the right to engage in individual attorney's activities. Your right has been suspended since 2020 based on the attorney's application. You also declare membership in the National Bar Association of Ukraine. Can you please explain why, having the permanent place of residence in Kyiv, you acquired the attorney's certificate in Poltava, and how did you combine the status of the prosecutor with the procedure of getting this attorney's certificate? Thank you, dear Commission, for your question. Your question is clear to me. Yes, living in Kiev on a permanent basis, taking into account the line in Kiev and Kiev region, and existence of court disputes regarding the Bar Council in Kiev, and the line of people waiting for that in Kiev, based on Clause 2 of the decision of the Bar Council of Ukraine, it was allowed for persons who wanted to become attorneys to undertake exams in any other region of Ukraine. In connection with this, I analyzed information from different bar councils of other regions, and it became clear to me that in Poltava region, the bar council did not have a huge line of candidates. So I chose the bar council of Poltava region. I'm sorry. Can you please name the bar council that you sent request to, except for the bar council of Kiev and Poltava region, while deciding on choosing a specific bar council? Thank you for your question. That were information requests to Zhytomyr, Rivne, and Cherkasy and Poltava regions, their bar councils. Can you please tell me, how did you undergo internship after passing the attorney's exam? This lasts 6 months. Thank you for your question. I've informed the Bar Council that I worked as a prosecutor, and according to the internship plan, I performed tasks according to the individual plan and instructions of my supervisor, internship supervisor. And I provided documents as it was specified. I undertook internship in time free from work, that is during days off and after work. This was also specified in the documents which I provided, and the Bar Council informed that I was undergoing internship outside of my work. How long did it take? 6 months? No, I mean in hours. According to the procedure, that is 550 hours of free time during 6 months. Can you imagine just yes, I was filling in the individual plan. I provided to the Bar Council. It adopted it. My supervisor adopted it. This was individual plan outside of my working hours after 6-7 p.m. every day, and I used the weekends as well. What was the purpose of getting the attorney's certificate, taking into account that immediately after taking the oath, you submitted an application and suspended your certificate? Back then, at the beginning of the procedure of acquiring the attorney's certificate, there were no prohibitions regarding that. I wanted to obtain the right to engage in entrepreneurial attorney's activities, but I didn't have the purpose to start working as an attorney immediately after getting the certificate. Back then, I can inform you that there was the reform of the prosecutor's office. I didn't know how it will go. So with respect to me, whether I would pass it or not, because it was, I didn't know the result in advance. So I had the right, there were no direct prohibitions to get the right to engage in attorney's activities, and I did that. As of now, realizing that there are respective decisions of the Supreme Court, I've submitted an application in 2023 to the Bar Council of Poltava region with respect to the liquidation of the certificate. I've sent all the documents to the Commission confirming my words. Yes, thank you. We have seen these documents. Can you please tell me? In the internet, at the website Anti-Corp, Boyko, on the 13th of June of 2017, published material chickens of Pshonka in the military prosecutor's office have become wild birds. I do not want to refer to these materials because, in my opinion, this is not very correct, even the questions itself. But with respect to this, I would like for you to explain firstly what this article is about. So, namely, it states that you had 162,000 hryvnias. If I'm not mistaken, you've explained that previously as well. Let me finish my question, but maybe I'm mistaken. That's the first point. And the second point is that there is a reference that prosecutor Kravchenko provided inaccurate information about the location of a former president. Please.
Thank you for this question. Esteemed Commission, I have explained the 162,000 hryvnia. These are the savings that I have declared at the end of 2016, 2017, and they were saved over 2015/16. As for the mass media publication, I would like to explain that I have respect for the mass media, but these publications are manipulating the comments I had given. Further, I would like to explain that I was a prosecutor for the public charges in a criminal case against the former president of Ukraine, and we took all the steps to uphold the right of defense. There are procedural documents that had to be served after the notice of suspicion and also throughout the trial. So we had taken all steps. In particular, we sought legal assistance from the Russian Federation. In response, they told us they would not serve any documents, ignored our requests, ignored our legal demand to hand the procedural documents. However, the General Prosecutor of the Russian Federation told us about the address of registration and stay of our defendant. We also received information from the defense about his registration and residence, and that was in the city Rostov-on-Don and the particular address. But later on, when our request was ignored by the Russian Federation, we did not stop, but used international courier service, Dimex and others. We made 3 attempts to deliver, and on 3 occasions we received the answer. Once, a woman in uniform went out and refused to receive any documents. The FedEx service replied that at the said address, the warehouses are located. When giving the comments, as part of the prosecution case, and I provided this information to the mass media and TV channels, and I have said that, as seen by the prosecution service, that the Russian Federation and the prosecution servant of the Russian Federation has notified the information which is not accurate. The address is not true. I did say so. I made a number of references confirming our opinion, and the Commission is free to review them at their discretion. So I can assure you that this is a distortion of my words I had used when giving comments to the mass media. I hold one thing. When you said the Russian Federation, you spelled with the small letter, not a capital letter. I did say so, and I provided so in my explanations. I will narrow down the question, if I may. It's about the alleged connection with Mr. Matyos, so I have to ask you the question. Do you maintain friendly or any other relations with Mr. Matyos? Let me ask you, are you directly or indirectly part of his circle of influence? Thank you for your question. I would like to explain that as of today, I do not maintain any relations with Anatoly Matyos, friendly, nor professional, nor any other. At the time, when I worked at the prosecution office, he was the lead military prosecutor. We had only professional and working relations with him. He hasn't given me any illegal instructions. He did not influence on my independence, my principles, my results in the criminal proceedings are manifestations and proven by the verdict passed in cases where I was acting as a prosecutor. Many such indictments have been upheld by the Supreme Court of Ukraine. The last time I saw him was 2019, when the trial on Yanukovych was completed, and that was February 2019, and I haven't seen him since. So, talking about your principles, I have a question connected with your status of the attorney, and then you revoking the status. So you have revoked your status as an attorney. Do I understand you correctly? Yes. So let me ask you. On the one hand, you're demonstrating that you're a man of principles, and on the other hand, following your answers to the questions, and you've told us when you applied for the competition, knowing that you are a candidate for a serious position, you have refused your right to pursue your career of an attorney. So what are the safeguards from you renouncing the position to which you are applying currently? Thank you for the question. I would like to give the following explanation. In my life experience and in my professional experience, I have come to understand that there's nothing unrealistic in this life. So when I set out to pursue a goal, I achieve it. This is confirmed by my statement and also my achievements. As for the attorney license and the right to practice law, I could say that at the time I did not have a direct prohibition. I had the right to obtain the attorney license, the right to practice law. I did so, I passed the law and confirmed my knowledge, and the Council of Attorney, the Bar Association of Poltava, confirmed my knowledge and my capacity to practice law. I did notice the Bar Association of Poltava that I was not intending to practice law as a defense counsel. I aimed to obtain a license and confirm my knowledge. So, considering the above, should I be elected to the position, I have one goal: to work until the end, until the result. Thank you. Karen, over to you.
Yes, good afternoon. I have two questions. My first question is, we proposed to the previous candidate a question about disciplining subordinates. Our question specifically, and I'm asking you the same question, is, should it come to your attention that one of your subordinates may have committed a violation not necessarily of the Criminal Procedure Code or criminal laws, but of the conflict of interest or codes of ethics rules of NABU? What would you do with that information? And what, in terms of your principles, do you see your responsibility in terms of allegations against a subordinate?
Thank you for the question, esteemed members of the Commission. Should any information come to my knowledge about my subordinate committing a disciplinary violation or a criminal violation or any transgression, I would react immediately in the following fashion. If this is a disciplinary violation, I will call a disciplinary commission. I will launch the procedure of in-service investigation. I would also call a meeting with all the staff. Once the decision is made by the qualification disciplinary commissions confirming or disproving the alleged violation by my subordinate, I shall make the relevant decision about holding the subordinate accountable disciplinarily. If the employee commits a criminal violations, as soon as I shall come to know of it, the general prosecutor shall be informed about the commission of the criminal offense. Therefore, upholding the principles of NABU, I shall be open before the society, and I will not hesitate a second about how to act, but will respond promptly according to the powers vested in me and according to the law, should my subordinate commit a disciplinary violation or a criminal offense. As for the second question, I will take all these steps under the powers vested in me to prevent the disciplinary violations or criminal offenses by my subordinates. I shall hold meetings, trainings under my powers and administrative resources given into my disposal. I will perform my duties under the law. I will make use of all the administrative toolkit given to me to prevent the negative events, and should that still happen, I will take all the steps to hold the individuals liable either disciplinarily or under the criminal law.
Добре, будь ласка, Драго.
Fine, thank you. Drago, over to you.
Thank you. Good afternoon. So when you were having your working address in Poltava on 110 Pushkina Street, you gave a very strange email address of this, let's say, to contact you. So my question is the following. Who is Max Naumann, whom you used as the email address?
Дякую за запитання.
Thank you for the question. As for the address stated at Pushkina Street, there was a lease agreement. It lasted 3 months. I did not declare the address. I did not declare the address. I did not live at the address more than 183 days. As for the email, Mas Norman, this is my email at the time, which I used at the time, and I had provided it at the time. So, this is the name of the email address. I did not disguise it. I used it in other documents in my correspondence with the Bar Association of Poltava, and I used exclusively this address. I also used this address for other day-to-day correspondence.
Yeah, okay, but who? Sorry, Mikola.
Будь ласка, Драго.
Follow-up question. So you're saying that you were using the same email address or not? And if yes, who is Max Naumann?
I did use this address, and Max Naumann is no one. It's an imaginary person. It's just a name in an email address.
Хто був, ви знаєте, що це за історичний герой? Як вам...
Do you know the character? In my understanding, this was not a historical character. Max Neumann, from English, Neumann means a new person. At the time and now, it's just an email name for me. Have you ever Googled Max Neumann? No. Thank you. So you have no associations with the person, and you never met him? No, it's just an imaginary alias for the email I've used long before work. So we would recommend checking it after the interview and replacing it. I'm doing that. Karen, over to you.
So my follow-up question is about going back to the question related to Mr. Matios. When you worked for Mr. Matios, did he award you with any honors or any other kind of recognition for your work in under him in the prosecutor's office?
Дякую за запитання.
Thank you for your question. I would like to explain that the awards were conferred to me by the general prosecutor at the time and not Mr. Matios, and the state awards was conferred on me at the time when Matios was holding his position by the president of Ukraine. I have not received any awards from the hands of Mr. Matios. Fine, Alexei. We have the information that in 2020, you crossed the border on a vehicle, Lexus GX 460. If you could please let us know why this happened, who owns the vehicle, and why you have not reported its use in your declaration. Thank you for the question. I would like to explain. This was me crossing the border on the way to Hungary. We were going to Hungary with my wife and my parents-in-law. The vehicle belongs to the in-laws family. I have nothing to do with this vehicle, and I didn't declare because I haven't used it a single day. I did make this trip as a passenger, and it was a 4 to 5 day trip, and I never drove the vehicle. I think that is verifiable. Because the relevant agency will state the driver of the vehicle. Kirill, over to you. Ruslan, let's go back to the matters of your professional conduct. And I have a question. February 22, an NGO files an application with the investigative department of the National Police of Bucha about registration of a criminal case about one of the MPs of Ukraine. There was lack of action. In the opinion of the court, there was a court ruling entered, and the court decision resulted in the initiation of the criminal case. Based on your answer, from 2018 until the 18th of 2022, it was under the investigation of Bucha, National Police Department. The prosecutors from Bucha, the district prosecution, were the prosecutors on the case that you are in charge of. I can see some decisions about revocation, about annulment. So first, let's discuss the subject. According to the information, it's about a member of parliament. I may not know the matters of the investigative jurisdiction well, but is it the investigative jurisdiction of a district police department? No, I would like to provide my explanations. The violation of Article 418.01, the duty of the investigative judge of Irpin court, the local police department was obliged to register the criminal case based on the fact of the alleged criminal violation by an MP, because the data in the Unified Register of State Investigation can only be made by the General Prosecutor of Ukraine. Starting from the outset, in my opinion, the decision was made illegally of the investigative judge of Irpin court. Later on, the police officers of the district police department, without going to the court, without informing anyone, went to the investigative judge who made the decision, asking for explanation how they are to implement the court decision, because there's a direct prohibition stipulated in the criminal procedure code. So they entered the case in the Unified Register. Unfortunately, the prosecution has no means of revoking the registration of a case in the Unified Register under the current law. So we received the notification from the police department. The prosecutor was identified under the decision made by my deputy, and accordingly, this was a prosecutor of the Bucha district police department. 4 requests were made. The police failed to provide the materials. After the 4th request to the police, we did receive the case materials in order to look into them and look for mistakes in the case summary, whether any abuse had taken place, whether it was whether any mistakes were made during the case registration. The prosecutor had to look into the case materials. Once we received the case material, we could see that the prosecutor pressed different charges compared to the ruling of the investigative judge. The prosecutor looked into the matter and filed the motion with the prosecution and asking the case to be assigned to NABU under its investigative jurisdiction. The in-service investigation was initiated about the alleged violation of ethics, professional conduct, bias on behalf of the prosecutors, and the in-service investigation was initiated about the examination of my conduct, the conduct of my deputy, and procedural leader. We provided the explanation. Myself, my deputy, and the prosecutor, the case prosecutor, were asked questions. We could see that we could consent to the interview with the polygraph test. I provided the explanation to the polygraph test, and no violations were detected. No violations were detected with my deputy and the case prosecutor. And this was the end of the in-service investigation. So I do feel that some specific violations were made by police officers and the court, and we are filing an appeal to the High Council of Justice when it is launched, as this is a specific case, and the head of the National Agency for the Prevention of Corruption did mention a violation of the current laws.
Okay, Ruslan, can you please tell me or comment somehow? I see that I'm looking for your autobiography. In 2014, the position of senior prosecutor of Lviv prosecutor's office, September of 2014, March of 2015, you participated in the anti-terrorist operation in Donbass. And I see in those areas that are unfortunately very well known right now. And then you come back to the main military prosecutor's office of the Prosecutor General's Office of Ukraine. So what you were governed by when you came from the regional prosecutor's office to the specialized military prosecutor's office? Thank you for your question. As I've informed I studied in the military lyceum in Kiev, and then I entered the military faculty of the Yaroslav Mudry National Law Academy. And after graduation, I went to the garrison, where at first I served in the military prosecutor's office. So in 2014, on the 3rd of September, upon my own initiative, I was included into the military prosecutor's office. They were in the zone of the anti-terrorist operation that was in Debaltseve. Upon occupation of Debaltseve, we moved to Artemivsk. Upon my return in 2015, I was still an employee of Lviv military prosecutor's office of the Lviv Harrison. At first, I came back to Lviv, and then I was transferred. Yes, please continue. And then I was transferred to the investigative group of the Prosecutor General's office. In the investigative group, I worked for almost a month. Upon result of the work, they were satisfied with my work. And then the Prosecutor General Shokin hired me to the Prosecutor General's office of Ukraine upon results of my work in the investigative group. Okay, thank you. Thank you. Yes, please, Alexei. Thank you. I would like to come back to the question that I already asked. If you need more water, please ask for it. Look, with respect to vehicle Lexus with which you crossed the border, right? You say that you do not use it, back then you were just inside the car, right, as a passenger? Yes. We have information, and this information is available in the register, that you received the power of attorney from the owner, that is the father of your wife, without names, on the right to use this vehicle till 2028. I would like to say that, thank you for your question. First of all, I don't know that there is any power of attorney issued in my name, because I was not present during any issuance of any powers of attorneys for vehicles. I don't know about that at all. You can check that. I agree, and I will answer that I will provide all supporting documents that I don't know about that. Can you please show me this power of attorney? I will show it later. As of now, no one has given me the keys or the vehicle or the power of attorney, and I was not present then when he issued this power of attorney. Has any vehicle been transferred to you, for example, in 2019, in September of 2019, under the power of attorney? There were no powers of attorneys issued in your name from your father-in-law on the use of the vehicle. On driving, no. I know that my mother-in-law was selling the vehicle, and together with her, I went to the service center. I was helping her because my father-in-law was away, but that is a completely different vehicle, Mercedes. So there is the right for another vehicle, not the right to the vehicle, to represent interest of my mother-in-law during the conclusion of any transactions. Okay, clear. The question is more related to your political neutrality as well. You probably know that your father-in-law is a member of a political party for future. I don't use any measures, and I don't ask any questions about activities of my father-in-law, and in turn, he does not try to influence my activity in any way. All his affairs are his personal affairs. Okay, clear. There is also information that your wife was this paid assistant of people deputies from the party regions and from Yulia Tymoshenko bloc during the period of 2012 to 2014. We have to ask this question, whether you have any political affiliation, bias nature, attitude towards any political activists or parties. Thank you for your questions. Dear Commissioner, I confirmed my political neutrality with my deeds and with the results of my work, and with verdicts received in the Court of the First Instance, Court of Appeal, and the Supreme Court regarding political neutrality. I brought to responsibility the former president. I confirmed his crimes with evidence. He was recognized as guilty by the first instance, second instance, so I'm completely politically neutral. My family has no influence on me. My principles and the purpose, as I've informed previously in response to other questions, are more important for me than any influence of any other people or their vision regarding political activities of any family members or in their understanding and vision of my deeds. So my father-in-law has never influenced me in life. I do not live together with him. We do not have any mutual rights, affairs. So I'm completely independent as a prosecutor and as a citizen of Ukraine. Thank you. One more question, if you allow.
Окей.
Yeah, okay, Karen.
Добре.
Yeah, Karen, please, you're welcome to ask your question.
So just following up on the power of attorney, my understanding is that in Ukraine, in order for a power of attorney to be issued to for a person, that their passport information has to be provided and included. So just clarifying, you're saying that this power of attorney, if it has your passport information in it, was issued without your knowledge? And how would somebody obtain your passport information without your knowledge?
Дякую за запитання.
Thank you for your question. Dear Commissioner, I would like to explain that I did not transfer my passport data to issue any powers of attorney. When I was asked for that, then I gave my passport data. So if we may conclude that the family of my wife had my passport data, they could, if this power of attorney is really issued, I don't know about that, but I want to check this. If necessary, I want to get necessary information for a check, and then I can provide all supporting documents. But as of now, I don't know any about existence of this power of attorney. I can only conclude that probably the family of my wife had my passport data, and they could issue this power of attorney without my presence and without informing me, if they use them, if there is such a power of attorney, of course.
It's true.
Будь ласка, Олексію.
We can do
Yes, please, Alexei.
Наступне питання.
Next question. You are a prosecutor of a quite well-known settlement, not only in Ukraine right now, but in the world as well. Can you please tell us your professional activities in connection with those crimes that were committed during the period of the large-scale invasion? Has it somehow influenced your professional activities, or of course, if it's non-disclosure of the secrecy of the investigation? Can you please tell us how have these circumstances influenced your professional activities? Thank you for your question. I can explain that for me, this is a very important experience. That is the main experience in my life regarding my work in extreme circumstances, organization of work under my management. I had not only subordinates of Bucha Circuit District Prosecutor's Office, but also police officers and other special units of the Ministry of Internal Affairs and other special law enforcement bodies. I organized several directions of documenting of war crimes. That is, inspection of dead bodies on the territory of Bucha and so-called mass graves. Second direction was questioning and interrogation of all witnesses and all potential victims. All police officers, police of the prosecutor's office and law enforcers have walked around district by district in Bucha and questioned all the witnesses. Thanks to this approach, we managed to identify Russian service members, which became a ground for notifying about suspicion and sending to the court with respect to Russian service members regarding committal of war crimes by them. I also organized the process of identification and study of Russian service members, in particular with the use of provided opportunities regarding artificial intellect. We used this AI tool. The law enforcement bodies have established a list of service members who were probably present on the territory of Bucha. We uploaded photos into this software program. It provided us 2 free photos as confirmation, and then we identified the connection of service members with respective military units. And this way, we formed photo dossiers for each service member who was probably present in Bucha. After that, using this photo dossier, we showed it to all victims and all witnesses. We were showing these photos to them for probable recognition of specific persons. This direction of work has also provided results, as I've informed. 13 service members of the Russian Federation were notified about suspicion, and we sent these criminal proceedings to the court. I've also organized a survey and inspection of scenes of damages and destruction scenes together with experts. We not only inspected, but we also used technical assistance, that is drones and UAVs. We inspected the scenes. Then specialists provided us with 3D models of the territory of Bucha together with destructions, with marks where we found dead bodies. In view of the above, we've organized many directions of work, and these events have provided us with extensive experience, but unfortunately not very pleasant experience, because we have a lot of people who died, ordinary people who just lived there and were in the streets and they were killed. Yes, thank you. Dear members of the Commission, I would like to address you right now. We have 4 minutes left within the time slot allocated to our candidate in order to continue the interview, even though not too long left, but still, even if we have 7 minutes, we will exceed the time slot. I would like to vote right now for the possibility to extend 1 hour interview with our candidate and to use additional time that we will need. So I, Kucheravenko Mykola, is in favor. Alexei is in favor, Drago is in favor, Kara is in favor, Puvilas is in favor, and Kirill is in favor. Thank you. Let's continue our interview then. Can you please tell me, on the 20th of August of 2018, you privatized the service apartment, and on the 23rd of November of the same year, you sold it for 816,000 hryvnias. At the same time, on the 15th of March of 2019, you married your wife. Back then owned an apartment in Kyiv with a total area of 89.9 square meters. So, as of the moment of privatization of the service apartment, your family did not require improvement of living conditions. Can you please explain this situation? Thank you for your question, dear Commission. I've provided extensive answers and explanations regarding this question. I can briefly explain that in 2018, I received a service apartment. Previously, I was in the line since 2015. I didn't have my own real estate property. I lived in an apartment which I was renting. with an area of 33 square meters. And then in 2018, in December, I received an apartment, service apartment, with a total area of 42 square meters and with a residential area of 17.5 square meters. Having received the service apartment, I registered there. I did not register any family members there, my future wife or parents, no one else. So I was the only person who was registered in this apartment. After that, according to the commission decision of Podil District Administration of Kyiv, there was taken a decision about the transfer this apartment from the status of service into the general status. Then I obtained legal grounds according to the law of Ukraine on privatization and the residential code of Ukraine. I received the right to privatize it since I did not privatize any property in my life before that. Using this right, I privatized a small apartment with an area of 42 square meters. This is the total area. 17.5 is the residential area. I used my rights, legal rights. And at that time, my wife had her own real estate object, but this was her personal property. I have no relation, had no relation, and will never have relation to this apartment in terms of rights. So existence of the apartment of my wife did not prevent me from using my legal right for privatization. After privatization, I analyzed the market and I saw that it was possible to buy property rights for building under construction. I sold this apartment with the intention of buying property rights, and it allowed me to increase the area. In December, and I did that in December of 2019, and I acquired property rights for a future apartment. All these actions were recorded in my declaration. I was not hiding anything, and my wife as well. So my wife's apartment is her private property. My privatization is also my private property. And the law did not prohibit me to do that. I acted in line with the law. I did not commit any violations. Can you please tell me, among persons who can provide references to you, you've mentioned the head of Obolon District Court, Devyatka. According to the publication of ProSud project, Judge Devyatka took a decision about apprehension of Alexei Saliba and deprived of the driving license to participants of auto rally. The opinion of the Public Integrity Council stated that this Judge Devyatka did not comply with the integrity criteria. Subsequent actions of the judge were recognized as unlawful, but it was impossible to bring him to responsibility because of the expiration of the term for bringing him to responsibility. Can you please explain why you chose this particular person as a person who can provide references to you? Thank you, dear Commission, for the question. I can inform with respect to statements about possible lack of integrity of Judge Devyatka, about the signs of disciplinary offense in his actions and the closure of disciplinary proceeding. I would like to point out this information is not accurate, which is confirmed with the following. I have provided these explanations in writing, and I have confirmed it in the attached documents. In July of 2019, Judge Devyatka passed qualification evaluation and was recognized by the QCJ as the one who has integrity. I provided references in my explanations. The interview with him lasted over 3 hours, and all actions of this judge were evaluated in detail. Having received all explanations and studied materials of the cases, the HQCJ did not find significant violations in the actions of the judge. I've also provided a video reference. The High Council of Justice also evaluated actions of Judge Devyatka during Maidan, and the case was closed not because of the expiration of term, but because the judge did not violate the oath while taking a decision mentioned in the publication of pro-suit. So this information is not confirmed. I provided the explanations. Why I chose this particular person? Because this judge, this person fulfilled his authorities as a judge while supporting public prosecution in many of my cases. I believe that this person can objectively describe me, how I work in the process, because he witnessed it during the process. I do not have any friendly relations with this judge, and I've only asked him whether I could submit him as a person who can provide references, because in my opinion, he can objectively describe me and describe my actions in the process.
Karen, over to you.
So my first question is regarding the apartment. You state that you received that as a part of your work as a prosecutor. Is this standard procedure for the government to award all prosecutors such an apartment? And my second question is, was any former supervisor, including Mr. Matios, involved in helping you to obtain that apartment by signing any official documents that gave you that right?
Дякую, шановна комісія, за запитання.
Thank you, esteemed members of the Commission, for this question. I would like to explain from that in the period from 2015 to 2019, about 70 people from the number of the military prosecution office were issued apartments. I skipped my queue on a number of occasions because big apartments were given to the military prosecutors, and I was single at the time. I did not have the children, and the big apartments could only be issued to the officers with families and kids. About 70 military prosecutors received an apartment from 2015 to 2019. The number of civil prosecutors that were issued apartments is not something I know, but this information is verifiable at the office of the general prosecutor. As for signing the documents, Mr. Matios signed as the chief military prosecutor at the prosecution where I served, the documents that were submitted to the office of the general prosecutor. At that time, the person acting as the general prosecutor of Ukraine verified the information submitted by myself, so Matios provided his approval, but the final decision was made by the general prosecutor or person acting in this position, and the very last decision was made by the Housing Committee of the district administration that issued the apartment, and the decision was made by the committee of the district administration of Kyiv. Thank you. This is my answer. Drago, over to you.
Yeah, but two short questions. The first one is, let's say you're doing, let's say, very sad but also very important job in Bucha. So why would you like now to move to NABU? That's number one. And number two, did you write your application for the position of the NABU director by yourself, or there was somebody else who helped you with that?
Дякую за запитання. З вашого
Thank you for your question. If I may start with the second question, you're asking me about my autobiography or my application?
Application.
Можу повідомити, що всі документи
I can assure you that I found and drafted all the documents independently. I made a technical mistake in my autobiography. I admit it. It's true. I did make a mistake. I was using the documents that I had used earlier when I submitted my documents as part of the military service, and where you are obliged to write in third person singular. So I made a technical omission, and so I said by him, not by me. I admit that I had made this mistake. As for the first question, drawing on my experience garnered in Bucha and drawing on my experience in Sevastopol, when only the military prosecution office was working to document the aggression of the Russian Federation, I was the only investigator for this Sebastopol garrison. As there were no people in the last 8 months, my colleagues and I arrived at all the military units captured by the Russian Federation. We did all we could under the critical environment, documenting, starting with the Sebastopol garrison. Then I moved to Lviv. Then I served in the anti-terrorist operation area. Then I acted as a prosecutor in a number of high-profile cases. My professional achievements could prove that I have extensive expertise, I have extensive life experience, that I am goal-oriented. Then I held a number of administrative managerial jobs under my leadership. I first had a department. Then I was the deputy prosecutor of the central region, covering 8 regions or oblasts. Later on, I led a unit in the military prosecution office. Starting in 2021, I led Bucha district prosecution office. I would like to thank all my colleagues who worked alongside with me and under me. And owing to my work, I gained extensive experience. I charged and proved the ex-president guilty. The court decision was held in the Court of Appeals, in the Supreme Court, and I can say that owing to this experience, I felt I was in a position to apply for this competition for the position of the Director of the National Anti-Corruption Bureau of Ukraine. I have one goal. I want to make history as the future leader of NABU, who together with SAPO could do everything possible and impossible to defeat corruption in our country. This is my sole goal, drawing on my secretarial conduct, my independent performance, leading subordinates. I'm sure we can do it together with SAP, with the goal, being goal-oriented and doing everything possible and impossible to achieve it. Considering the performance of NABU and SAP, I will cut you. Answering your question, this is my goal. If the decision is made by the Commission, we will ask you the question during the competence interview. Pavelis, over to you.
Thank you. I would like to continue with the question Drago asked. Have you discussed your participation in this competition with the officials, let's say from Parliament, government, President office, directly or indirectly through the somebody who represents them?
Thank you for your question. I fully understand your question. I did not discuss it with anyone. I started putting my documents together, and then the deadline was extended, and I made use of that because I wasn't making it within the first deadline. I do not personally know, and then I do not maintain relations with the representatives of the Office of the President, Cabinet Ministers, or other law enforcement institution. I haven't discussed it with the representatives of the General Prosecution Office. It was my personal decision. Once I made the decision and started putting the documents together, I only told my wife. Fine. Thank you.
закінчились.
I think we've asked the questions, so we shall call a short break. We would like to thank you and wish you all the best.
Продовжуємо нашу
Let's continue our work today. We have the interview right now with Semen Yurievich Krivonos with respect to his compliance with the integrity criterion. Prior to starting the interview, I would like to remind that you received the questionnaire. We will follow these questions from the questionnaire mostly, but in order to simplify perception, we form them in specific blocks: income, vehicles, land, etc. So each block will include several questions, which you are acquainted with. We will ask you to comment on them. I have a request to you. Please be concise in your answers, up to 2 minutes, no more than 2 minutes, because we may have also some follow-up questions or some other additional questions. Before starting, I would like to ask you whether you have any recusal requests to any members of the Commission. I have no recusal requests. Thank you. Thank you. Then let's move on to the questions. Please explain. In your asset declaration for 2016, you reflected income of your wife, in particular income from the sale of movable property in the amount of 234,000 hryvnias without indication of the source of origin, as well as income from provision into rent in the amount of 61,000 hryvnias. So, which documents can you use to confirm these sources of origin of income of movable property in the amount of that was sold? Thank you for your question. As I've informed the Commission previously, this income from the sale of vehicle Subaru Tribeca, which was owned by my wife starting from 2007, which she acquired under the credit agreement. I've also provided information in the materials provided to the Commission. It was sold for cash by paid at once. It was equivalent of $9,500 US, which was the market price of the vehicle back then. I reflected this price in the declaration, being governed by the principle of accuracy and completeness of declaring. With respect to the income, unfortunately, 61,000 hryvnias. Unfortunately, the rent agreement, as I've informed the Commission, has not been preserved, but my wife reflected this income in her declaration of individual entrepreneur as a result of annual reporting. That is income from leasing out her apartment in Kyiv. Thank you. Thank you. Can you please tell me? On the 19th of November of 2014, there was carried out search of Hyundai Santa Fe, which was in your actual use. This vehicle is registered for Chernenko Olga Olegivna. According to the Register of Powers of Attorney, Chernenko was your representative in 2014. Can you please explain the nature of your relations with this person and the grounds for the search of the vehicle? Thank you. I will start since the end with respect to the grounds of the search. Overall, I will tell you about this criminal case. This criminal case, and as has been mentioned by journalists many times, so it was initiated in 2014. In 2015, it was closed with the ruling of the prosecutor because of the corpus delicti of the crime. I would like to point out that no one has never been notified about suspicion under this criminal case. There have been no indictment bills. No person has been detained. Then in 2016, when I started participating in the competition to the NABU, and I worked as the first deputy of the head of the Odessa Customs, which was headed by Yulia Marshevska, I was responsible for the direction on combat with contraband. Because of my active work and because of closure of very serious corruption schemes. If you want, I can tell you in detail about all of these instances. Back then, employees of law enforcement, according to our information, participated in these schemes, and I even submitted a respective application to the Odessa prosecutor's office, and criminal cases were initiated with respect to employees of the pretrial investigation body. And because of my active work, the then deputy head of the prosecutor, Yaroslav Bendik, who, according to my information, is not working in the prosecutor's office anymore, took out this case from the archive and overturned the ruling on its closure and allegedly started investigating it, even though no procedural actions have been taken since then. The ruling on the conduct of the search was adopted based on procedural documents on conduct of covert investigative actions. It was used to undermine me during the competition, and when I won the competition for the position of the Odessa Territorial Division Director of the NABU. As of now, this criminal case has been closed. It has been closed because of the corpus delicti, so there was no crime as such. I would like to emphasize that I am a whistleblower of corruption and a person who offered a bribe to me, being the head of the central executive body of the State Inspection of Architecture and Urban Planning, has been detained. With respect to the nature of relations, very briefly, this is a daughter of my sister. I temporarily used this vehicle free of charge without conclusion of any agreements, and I've informed the Commission about that. Was it declared? In 2014, this right of use was not subject to declaring because there were no peculiarities. It was established in 2016, and I was submitted for 2015. Back then, I was working in Odessa Customs. I had Skoda Octavia as a service vehicle. Okay. Okay. We are following the vehicle questions. Your wife questions under the right of ownership owned from 2007 vehicle Subaru Tribeca, sold in 2016. Since 2017 vehicle Mercedes-Benz S200, sold in 2017. From 2018, in 2018, apartment with the area of 51.2 square meters in Kiev, sold in 2019. Can you please explain the source of origin of funds used to buy this property and provide information about your wife's income when these objects were acquired into ownership? Thank you for your question. With respect to Subaru Tribeca, I've partially explained. It was bought on a loan in 2007. After paying out the credit, it was sold in 2016, I guess, on the 19th of January, if I'm not mistaken. Of 2016, right. Funds received from the sale of the Subaru Tribeca were then used to buy vehicle Mercedes, as I've provided its value. The market price also corresponded to its value. And with respect to the apartment, these were basically my funds received from the sale of my real estate object. I provided supporting documents. The amounts are relevant there. They were more than enough to buy this apartment, half in the shared right of ownership for the apartment. The sister of your wife, Tkachenko Anna Alexandrovna, received a gift in the form of the house with an area of 151.3 square meters in Vyshgorod district of Kiev region. And your family uses this house. During the period from 2016 to 2017, she bought vehicle Audi Q5 manufactured in 2012, Volkswagen Golf manufactured in 2017, and Porsche Macan manufactured in 2018, in 2021. What do you know about these circumstances of receiving a gift in the form of the house and the source of origin of funds used to buy these vehicles? Thank you for your question. This house was gifted by the mother of Tkachenko. Formerly she was Pashinska Hanna Alexandrovna, that is the sister of my wife. It was gifted in 2009. I would like to point out that I've been married with my wife since the 6th of August of 2013. This house was built, as far as I know, by cooperative using funds which were invested back then by my mother-in-law. I've informed the Commission that I don't know. I've clarified this information. They were investing into cooperative. Cooperative was built in the house, and she acquired the right of ownership for this garden house. In 2009, it was gifted to Hanna. With respect to vehicles, I've provided documents provided to me by Hanna's husband, Timur Tkachenko, with respect to source of origin of funds. These are the funds from the sale of his real estate objects, funds gifted to him by his mother. There is a deed of gift authorized by the notary. They have been living together for a long time, and they use these vehicles together. Right now they are married, but back then they were just living together as partners. Okay. In your declarations for 2015-2016, you did not specify cash assets that you had and your wife had. According to the asset declarations for 2019, you declared cash funds in the amount of $45,000. Can you please explain the source of origin of these cash funds? Thank you for your question. I declared my real estate property, which was sold in 2018 under the sale and purchase agreement. The income received from its sale amounted to about 4 million hryvnias. I can't recollect the specific amount. And then part of these funds are declared cash funds in the declaration for 2019. Can you please tell me, with respect to this land plot, which you referred to and from which you received funds, the land plot with a total area of 1.986 hectares in a Buchev district of Kiev region, you bought from Tyshenko, according to the sale and purchase agreement in 2011 for 316,000 hryvnias. Then in 2018, that is 7 years later, it was sold for 4,345,000 hryvnias. Besides this, land plot was located on the lands of a forest of the forest fund, and together with other land plots was the entire land area. Then there was a range of court decisions with respect to this forest area and the land plot itself. Can you please explain the situation?
Thank you for the question. The price is stated at the point of purchase, and this is very important. I wanted to say I was not a public servant when I bought the land lot. And this is confirmed by my labor record book and the date when the legal deed was entered. The legal deed was made with a calculation 300,000+ hryvnia, so roughly $40,000, approximately $200 per 100 square meters. Later on, it was sold 7 years after the fact for 4 million hryvnia, considering the market prices. To talk about the forests, I was brought in as a third party into the case. When I bought the land lot, I did not know it. It was not an agricultural lot, and I don't think the final decision was made in a court case. The court is still pending at the Supreme Court level. Over to you. Why did you buy the land lot? as an investment. This land lot specifically was bought as an investment. It was 2011. This was a year when the real estate market was low, so I bought it as an investment. Incidentally, over to you, Kirilo. I just wanted to say that the cassation civil course of the Supreme Court of 2022 has reviewed the decision of the Obuchiv, has upheld the decision of the Obuchiv District Court at the request of the prosecutor. So has the new owner made a regressive claim to you? No. Fine. Now we are talking about land relations. I'd like to ask you, you own the land lots 4/71 hectares in Novoznamensky territorial community in Poltava Oblast, 025 hectares, 033/15, 023 hectares in Borodivka in Kremenchuk, district of Poltava, 065 and 065 in Pustovid in Kremenchuk district, 065 in Kremenchuk district of Poltava. Also, you used to own this land lot we had discussed. If you could explain the source of income to buy the said properties, the documents that you can present to prove that you were able to afford to buy them, that you could afford to buy them, and we are not looking into the inheritance of the landlord, your parents. So just, if you could just discuss the landlords that you own. Thank you for your question. 4.7 hectares is a landlord allocated from the lands in use of the farming company that was formed and belongs to my parents since 1992. So under the land code, the members of the farming company, and I was a member of the farming company in 1992, have the right to receive free of charge the average landlord for farming purposes. So we, as family farmers, used our right and were allocated 0.47 hectares free of charge. The amount, the value at the time of the acquisition is stated in my declaration. This is the value mentioned in the decision allocating the land lot. It is stated at the valuation, and I reported it in my declaration. 025, 033, and 035 are the landlords bordering on the household of my parents, issued free of charge by my parents within the free privatization to myself to build a house and for my household farming purposes. As for 3 landlords of 065, this land was leased by Kolos Farming Company, 21.4 hectares, in Vorkuty of Poltava region, and when the lease expired, the village council allocated 6,500 square meters to the employees. These lots were either leased somewhere, and that is verifiable through a register, and some others wanted to put it up for sale, and they were sold at market rates. I had enough disposable income at the time of the acquisition, that was 2019 and 2020. I was also the founder of the farming company. Moreover, I bought the 3 land lots. My mom bought 1 or 2, and I think my sister too. And the value, the overall value of this purchase was 90,000 hryvnia, with my income, and I had provided the supporting documents. I had quite enough official income to afford the purchase. And a similar question about the landlords belonging to your wife. 1.75 hectares in Бервиця, Brovary, in Kyiv, 0.12 hectares in Obuchiv district, Kyiv, 0.18 in Червоне Поле, Криворізький district, 0.09 hectares in Бориспіль, district of Kyiv, 0.08 in Brovary. So a similar question, what are the legal grounds, sources of income, and the goal? In 2010, through the decision of the village council, my wife had received a hectare, 0.75, that was before marriage. The same in Obuchiv, based on the district administration decision. I did not do the compliance of my wife before marriage, and she presented me the documents. This was a free granting of the land lot through the local administration. As for 018, it's the same name of my wife as her grandmother. So this landlord belongs to her grandma. And also half the house attributed to my wife actually belongs to her grandparents and is located on that land lot. I stated it as the use of the land lot as required by the declaration regulations under the Article 120 of the Land Code. She has the right to use because she has the right of ownership on the house. And 009, it's in Rohoziv village. This land lot was bought in 2018 from legal sources at market value. Talking about the purpose of the acquisition, my wife and her mother, after the death of the grandfather, had the idea to move the grandma and sell her parental house and build her homes and to have her closer to Kyiv, but they gave up the idea. The grandma refused to leave her house in Червоні Води. Fine. According to the declaration for 2020, as of 31/12/2020, you owned corporate rights, in particular, in a company, Global Legal Consulting Company, in a company B6, SFG Kolos, SFG Kolha. In a declaration for 2021, you are reporting the sale of your corporate rights. Could you please explain the sale of all the corporate rights, the value at the point of sale, and the individuals to whom you had sold your corporate rights? Once I was elected, I won the competition to the head of the city building department. I had the duty to sell the corporate rights belonging to me. My corporate rights in a farming company Olha and Kolos were alienated for the benefit of my sister. As for the corporate rights in the company GLCC and LTD B6, they were alienated to third parties. I can provide the names if needed. I did submit the information to the commission. The individuals are not related to me. I think I alienated GLCC to the other co-owner. As for LGD B6, I did not gain an income, and 44,000 hryvnia were received from the sale of the corporate rights in Olga and Kolos farming companies. I would like to say so. I made a mistake and I falsely stated the value of the corporate rights in the company, in the farming company Olga, $40,000 from Kolos, and I stated 3,000 hryvnia from Olga. 3,000 is a nominal value of the corporate rights. So it happened that I made a mistake at the time when I was filling out the declaration. I made the calculation, I didn't have the agreement in hand, and I thought this was the nominal value, 3,000 hryvnia, but the purchase and sale agreement of the corporate rights registered with the state register, they identical with Olga agreement, and the income was not corrected of 40,000 hryvnia, so the difference is 37,000 hryvnia. I should have reported 80,000 hryvnia based on the documents submitted to the registrar. I informed the National Agency for the Prevention of Corruption, immediately used my right to inform, to notify the mistake, and I would like to report that this is not my lack of diligence as a declaring entity, it's just a typical mistake made as I was filling out the declaration. Therefore, $43,000 is the income from Olga and Kolos. I have a question pertaining to political neutrality. According to the data of the tax service in 2020, you received the income as the self-employed person 500 hryvnia from Zhytomyr regional organization Servant of the People, Sluga Narodu. Could you please explain about the labor or any other relations with the party? Over to you. I would like to state that I have complied with the requirements for filing the application for the competition, and for 2 years I did not have any relations with the political parties, not just the Servant of the People. If I could explain the context, person I know, Viktor Yevdokhymis, who is a rector of Zhytomyr Polytechnical University, National University, who was then running for local elections in 2020, and he needed my assistance as a lawyer, not just my assistance, but my assistance too, to appeal some decisions of the Territorial Election Board. I wanted to offer my services pro bono, but for whatever their own reasons, accountability, they insisted that I be paid a nominal fee for my services. So I represented him at a trial in October 2020. Since I haven't offered any services, the decision was made and entered. It hasn't been appealed, so I represented him in a court case. So on the 8th of October, we prepared case, and on the 9th, I presented his interest in Zhytomyr District Administrative Court. It is clear. Any questions to the candidates? Alexei? Now that we've started the political block of questions, there's information that in 2008 to 2009, there's information that you were wanted under article of the Criminal Code, charged with allegedly giving the incentives to the students for voting for Butte Party. If you could please elaborate on the information. Thank you for your question. Very happy to answer it. I, as a student, led the student active blog, the student council, the public council. I've always been actively involved in activities, student activities of the university. And in 2007, with a group of students, allies. We went against the administration of one of the universities because they tried to make us vote for the candidates that the administration of the university preferred. At that time, the representatives of the law enforcement agencies attacked us. They acted brutally. They detained a few students. And there was no bribing. It's nonsense. There was brutal conduct. Physical force was used against us. I wasn't wanted. I wasn't in hiding, and that's all I can explain about this case.
Будь ласка, Повілас.
Повілас, over to you.
Thank you. My question is related to political neutrality. Commission have received information that you allegedly have connections with the newly appointed deputy head of office of the president, Oleksiy Kuleba. What would be your comment on this?
Дуже дякую за запитання.
Thank you very much for this question. I will just say he's deputy head of the office of the president, Oleksiy Kuleba. Yes, I know Oleksiy Kuleba. I can say that starting 24th of February, since the full-scale invasion of the Russian Federation into Ukraine, a few days later, myself and DM crossed the road as we are located on the opposite end of the streets, and I joined the operational headquarters together with the military, law enforcement, the National Police, Security Service of Ukraine. We supported the evacuation of the people. We supported making a list of the people who ended up stranded in the occupied territories. As for profession, and this lasted until April, and then we, maybe not end of March, we then returned to our duties as the state inspections. We were the first to resume delivered administrative services Ukraine, which were not delivered at that point. I'm not linked professionally with him. Moreover, I know the context of your question. Does he have any sway on me? He has no influence on me. Did he influence my decision to file this application for the competition? No, he did not. I have long aimed to work for the anti-corruption institution. I applied for the director of the territorial unit of NABU in Odessa, so it would be perfectly logical, given the opportunity, to apply the competition for the director of NABU of Ukraine. I jumped at the opportunity. So there are no doubts or reservation that the Commission should have about that. Politically, I am unbiased. I am absolutely neutral without any influence on me. Thank you.
Could I continue? Have you discussed your participation in this competition with any other officials, directly or indirectly?
Дякую за запитання.
Thank you for your question. Only when the members of my team at DM, I told them that I'm applying. Those following me, and that's 80% of my team at DM, are now watching the screens of their devices. Some were upset, some were happy, they were concerned about what would happen to the reform if I win, but I did not discuss it with the higher level officials. I'm entirely independent. This was entirely my decision. Thank you.
Thank you.
Будь ласка, Драго.
Drago, over to you.
Yeah, thank you. So I have a series of short questions. The first one is the following. In 2016, you have been selected to become the head of NABU in Odessa region. And I have two questions related to that. The first one is, was this after you have been, let's say, involved in the criminal process, which we discussed at the beginning? And if that's the case, did the, let's say, the selection committee or commission which selected you for to be the head of NABU in Odessa, did they know about the process where you have been accused of accepting bribes? The second question, also related to this one, even when you won the process, you did not want to take the position, so you returned back to the customs administration. So the question is, why? And the third question, when you were responding to the first question today, you said that your wife received cash for when she was selling the car. Let's say I know some things about Ukraine, and I think that that was the period when it was prohibited to accept payments in cash in such a huge amount. So what would be your comment about that?
Дякую за запитання.
Thank you for your questions. I will answer them with pleasure. Firstly, I would like to make a clarification. Drago, it might be a misinterpretation, but I've never been charged with bribery. I am a whistleblower of corruption and a whistleblower of corruption. Sorry. As for the members of the selection committee, for the position of the territorial unit of NABU, including the representative of the public oversight and the well-known anti-corruption activists, should have definitely known about the sad facts. And most importantly, when I was announced as the winner of the competition, the unit of the detectives of the internal control made special investigations after the fact. I did the polygraph test, and no violations proving my application in any corruption were confirmed. This was stated in his interview by Arten Sednik, former NABU director, to Mir publication, which is still published at the site of the National Anti-Corruption Bureau of Ukraine, where he explicitly stated that there were no grounds. As for my refusal, yes, at the time, if I remember correctly, I was 31 years of age. I wasn't mature enough. I wasn't experienced in dealing with the journalists, and I didn't have the experience of such serious competitions. I admit it was a mistake to decline the post and write my refusal, as I felt that the standing of the institution needs to be above my intentions. If this happened now, I would not have done so, not because there were no grounds to renounce this position. I was absolutely honest, clear, honest and transparent. As for the last question you have asked me, honestly, I'm a lawyer, and I believe I'm well knowledgeable in the law, but do not know about the prohibition of payments in cash. And I'll say I was working at the Odessa Customs, and my wife alienated the vehicle without consulting me. Still, let's compare. I use the principle of honesty and accuracy of declaration, and reporting the full value of the vehicle is consistent with the spirit of the declaration. To say the evaluation value is also a way out, and here we have a crisis between the circumstances of the sale, as mentioned during the early interviews, when the assessment of the vehicles were made at evaluatory value and the real selling price. So I think that for the declaration and electronic declaration, it's very important to provide accurate data and full data. This is, in my opinion, the standard of integrity. Thank you. Thank you, Kirillo. Semen, in your application of the candidate for the position of Director of the NABU, you mentioned the people who could give you references. Firstly, Mikhailo Fedorov, Vice Prime Minister of Ukraine, Minister for Digital Transformation, representative of the IDLO and Denis Movchan of the project Accountability, Transparency, Public Administration and Services Campus. But you have not mentioned any contact details of the individuals. As required by the questionnaire, is it an omission? It's a story mistake. Thank you for your question. It's a story mistake. I will not say it on air, but I will gladly give the details to the Commission. It's the information that could show
спільну роботу з міністром
You working together with the Vice Prime Minister for Digital Transformation. Could you explain? With the greatest pleasure, I will explain, because all the people that I mentioned as those in a position to give me references, I implemented the city budget reform. Mikhailo Fedorov is the key ideologist and the key driver for the creation of super powerful anti-corruption initiative. This is the only program in city building as well as other digital services. As he's the driver, together we've been working with him and with Danilo Molchanov, who leads the TAPAS project, Transparency, Accountability in Public Services, and they are initiating the developers and implementers of the reform in city buildings as for digitalization of services. And I think this is the best anti-corruption initiative, the digitalization of housing and construction, which helped curtail corruption, save lots of money, simplify access of the public to the administrative services in city building. Do you understand you correctly that when you are now answering the question of Pavilis, you answer that you have not discussed your application with anyone except your team? You have in particular mentioned that some were upset, some were happy for you, and some asked what's going to happen to the reform. So my question is, you're holding an important post, and you have work cut out for you. Still, you decided to change your track. Why? Thank you for the question. In reform, it's an ongoing process of improvement. There is still work cut out, but it's important to adopt the law, which has been voted and is awaiting presidential signature, which will digitalize administrative services further. With the permits will be automated, the acceptance procedure will be automated. Yes, a lot of work is still pending, but we have a cool team that will carry on the work, even should I win this competition and hold this high-level and responsible position at the NABU. So, let me say that we revamped the system when creating DM. We did not transfer the employees. It was an open competition. And when asking how ideal all was involved, we have a memorandum. We have the International Technical Assistance Agreement. International Development Law Organization was involved in the competitive selection of the employees of DM, did the compliance, assisted in drafting the documents for the competition, finalizing them, and kindly provided us the profilers who worked at experts for the commission, look at the psychological profiles of the candidates and issue their recommendations. If I may ask a follow-up question, as it does follow up from the question posed by Pavilis and Kirillo. You mentioned that no one except your team knew about the decision you had made to take part in the competition. So do you understand you verbatim that the Vice Prime Minister that you listed as a person that can give you a reference did not know that he has to give you a reference since you are applying? Mykola, thank you for the question. I did not seek advice about my application. I asked his team whether Mikhailo, I did ask Mikhailo in person, but I asked his team members if I could list Mikhailo as a person who could give me a recommendation, and he has given his consent. I know that for certain he does not object, and he's always been supportive of our achievements of digitalization. Seman, among other information, we received the information about the alleged connections, alleged ties. This is the information, so to say, no more about your alleged connections with Alexei and Yuri Horovy, brothers, and MP of Ukraine, Tetiana Plachkova. Could you confirm or disprove the ties? Thank you for the question. I disprove any connections. These are people who are implicated in the creation of the back office system. Tetiana is an MP. I will only talk about Yuri and Alexei Horovy. Under my information, they were implicated in the creation of the system of so-called back offices that accumulated the money. I'm speaking so openly, holding this high position. I'm saying so on air. I had a few on-air broadcasts at the YouTube. I did mention their names and I publicly stated that I'm not linked to them in any way, and I fully disprove any connections, and I fully condemn any manifestations of so-called people who sought the solutions on the housing market. My first question pertains to your current activities. There are some journalist reports about the scandalous construction sites. There are different sites, different assessments. So now that you hold the current position, do you envisage corruption challenges in the construction system as it exists today? What did you come across, and what was your response to the corruption manifestations in the organizations where you are employed currently? Thank you for your question. Yes, without doubt, corruption in construction under the expert assessment has been in the top 10 most corrupt industries. With the launch of DIAM, we've been able to deal with the bribes solicited for the issue of permitting documents and completion certificates. I assert confidently that we have built a clear system of control for the decision-making during the issue of the permits, including with the unified state construction system through double-checking the documents during the 4 stages, electronic queue. The inspectors do not decide, nor do I decide, what documents are to be reviewed by which inspector. It is defined by the electronic queue. It automatically assigns these applications amongst the inspector for the issue of the permit. We want to do the same with the certificates. We have the system automatically identifying the inspection dates of the construction site during their launch. All the actors file documents electronically. Nothing is filed in hard copies, and I made at least 5 applications to the law enforcement agency, 2 to the NABU, 3 times to the State Bureau investigation, because it was about my support about the solicitation of bribes and offer of the bribes under the Criminal Code of Ukraine. One was followed up on, and the others were not followed up for a variety of reasons, and I'm not free to disclose the details here. Talking about the corruption manifestation, we did respond to the scandalous construction site, did do the investigation, did issue writs confirmed by the courts of Prospect Peremoghi 58. It's a scandalous site. Following our inspection of DIAM, following our writ, the construction was suspended. This writ was challenged by the constructor, but the 6th Appellate District Court of Appeal upheld the decision. So I can continue talking about all the specific sites. As for the document review, we have a very clear system based on a manual, based on instruction, the decision-making and inspection of the sites. Going beyond the limits of an inspector is monitored by other units. So should an inspector arrive at the site, he has a clear to-go list. He has a body camera. We don't have body cams available for all the inspectors. About 50% of inspectors have body cams, and they rotate them. They record the examination procedure. This was covered by the known companies like Kowalska. They enjoyed being reviewed with the body cam. There's a checklist filled out, which is submitted to the central office at DM. The unit checks for compliance of the checklist, etc., etc. Then I verify the information in person. I receive the reports about the sites, and then the inspector accepts the decision about the issue of the certificates. It is clear. Thank you. Staying in Odessa, working at the customs. You mentioned Yulia that you had worked with. You're linked with the Simple Solutions office that you were connected to. So, as for the group of Mikhailo Saakashvili and your political neutrality, what links you? What is the story of cooperation, and what are your current relations? Let me start at the end. Very unfortunately, Mikhailo Saakashvili is virtually imprisoned, and he is slowly tortured, and he's in a very bad condition. So I fully support the urges to free Saakashvili. Our cooperation started in 2015. I was working for the Chief Administration of Justice of Odessa district at the request of the Ministry of Justice. I was seconded, so to say, to the Odessa Oblast State Administration to open the new public service center. This was the first administrative services center, similar to the Georgian model. We developed the regulations, drafted the pilot projects. Since then, I know the team of Mikhailo Saakashvili. Afterwards, when he left the position of the head of Odessa Oblast State Administration, I joined his political project for a time. Until 2018, I led the Kyiv representation of this political party, and then I decided to pursue my legal practice. So I forsake my political activities. This was happened when he was illicitly expelled out of the country, and when he returned to Ukraine later, I led the Executive Committee for the National Council of Reform. He invited me as a lawyer to join the group drafting the laws. If you're interested, I'm happy to go into our activities, our simplified access to the electric grid, streamlining labor relations, etc. Thank you. I have another question. In 2019, your wife acquired the claim under the loan agreement for 29 million hryvnia. You don't know the fact for 24,000 hryvnia. What kind of deed is it? Why was it reflected in your declaration? Thank you. Thank you for your question. In 2003, the parents of my wife, Polshenska Olena Vladislan, and now deceased father-in-law, who is the Helena's stepfather, bought a house in Hovchere. We don't need to go into the names. I was trying not to disclose the personal details. So they bought the house in Brovary. I can now demonstrate a picture of the house. It was built in 1999. I'd like to show it. This is the house. They bought it in 2003. Then in 2007, they placed it as a collateral with the bank. They wanted to invest in business, and they were issued a credit line. Then in 2009, because of the financial crisis, they could not pay the loan. They paid some of the interest, repay some of the lump sum. So there's a difference between the loan agreement, and the changes were not entered into the loan agreement because it had been partially settled. And the litigation ensued about the collection of the debt. They filed a counterclaim about the review of the mortgage agreement and the loan agreement. There were about 6 of them, and resulting in 2019, the Deposit Guarantee Fund sold the pool of the loans to one of the financial companies, and then representatives of the financial company negotiated with my mother-in-law about the purchase of this debt. I do not know details of the negotiations, and it was decided to buy out as a debtor. She could not be a party to the concession agreement for a number of legal reasons, when 2 parties of the deal cannot be bridged. So this legal deed was entered with my wife, who then used her right under the law on mortgage and collected and accepted the house and the landlord. So it has belonged to her family and still belongs to her family. Formally, it's my wife, whilst earlier it belonged to her family. Why didn't I report the loan obligations? Because until 2019, and I did present the documents to the committee, this claim agreement was conceded to the third parties, and since it was conceded to the third parties, I did not report it in my declaration. Kirilo, do you have any questions? Any questions we would like to ask the candidates? Povilas, over to you.
Yeah, sorry, that's maybe will be the last question. Look, it seems that you have many contacts, connections, including with the politicians and decision makers. What makes you to be certain that you will be able to withstand a possible influence from all these officials or decision makers?
Дякую за запитання.
Thank you for your question. I can assure you
Тим, що в 2016 році
that in 2016, say,
команді Юлії Марушевської
when I was in the team of Yulia Marushevska, implemented the reform, we were faced with great resistance from the decision-making. The head of the State Fiscal Service and some law enforcement agencies, some policymakers, some smugglers did not stop me for a day, for a second, with the implementation of the law, cutting the smuggling routes. The implementation of the reform of the State Inspection of Architecture and Suitability is no easy stroll through the forest. It's a challenging work that from the start, despite the support of some politicians, such as the Minister for Regional Development, Alexei Generashov, has been constantly faced with resistance. It's not just dealing with the politicians, it's a challenge, a lot of interests amongst certain business circles, including those linked to the government, try to impede the implementation of the reform. So I'm trying to make a point that I'm unbiased and I'm independent of any influence on myself in the exercise of my powers. Just the fact that I'm a corruption whistleblower as the head of the agency, there are few that had reported that bribes were offered to them, and this was an offer made by the capital construction company. This can demonstrate my independence as the head of the State Inspection for the Suitability. As a director of the NABU, I would continue upholding high levels of integrity, independence, and will not sway to any political or any other influence. Thank you. Povilas, do you have a follow-up question?
No, thanks.
Дякую.
Сенків, будь ласка. хвилинку, Кирила, я дивлюся.
Kirilo, I'm checking the watch. We have about 3 minutes left before the completion of the time limit, or we need to make a decision to extend it.
Дуже вам дякую. Можна трьома хвилинами скористатися?
Could I make use of the 3 minutes remaining
Я вас дуже прошу.
to make a reply? Okay.
Хочу сказати, це важливо, щоб
I'd like to say, and it's important for the public to hear, for my staff, my team members to hear. I'm sure they're stuck and glued to their screens. It's a great honor for me to report to the Commission now, and it's a great opportunity. And I'd like to underscore that the reform that we implemented at the state inspection of the city building has happened, has been successful. It's truly anti-corruption. If we imagine 2 years ago that the former head of Derby applied to the competition of the director of NABU, we would all know where the back offices were and what was the payment per square meter. And I'm very proud that the Commission did not have the questions. This is a reply as an advertisement. Dago, over to you. You have a question?
Yeah, 1 minute. 1 minute. So you said that 80% of your staff is supporting you. What about the remaining 20%?
Дуже слушне запитання.
It's a very good question. I just know the feedback of the 80 and 20 haven't been surveyed. So this is where I'm taking my numbers. Or maybe 100% are supporting my application for the competition.
Дякую.
Thank you. All the best. Thank you.